And then the order passed by the Deputy Tribunal Cuttack as well as the Appellate Tribunal Kolkata in rejecting my surface application on the ground of delay on 148 days.
Yeah.
I have filed the medical certificate before the.
No, where is the provision for condonation of delay? Beyond a particular.
As per our High Court decision, the limited surface application.
You get us.
There are three judgments governing.
What is the legal position? What the apex court said on them?
Apex court is a case is sub judice measure. Well, sub judice case, judge case which is arising out of Kerala High Court. The case, the said case is sub judice, and notice has been issued indicating when the similar provision under Section 18 and the Limitation Act is applicable, then why the same should not be applied to Section 7? That I am handing over the issue.
Let you take notice, issue emergent notice. Office.
Number 1, 2, 3 for the statement, 5% procedure.
3 emergent notice to 5. Cabinet AGA Mr. Behura, will you accept for 3 and 4?
3 and 4. With the lecture and something.
Okay. Next.
Item 2, WPC 10418 of 2026.
Please, your Lordship, Milord, on behalf of the Mr. Mishra Milord, the present petitioner Milord is a borrower Milord. And he has availed a house building loan.
How much?
Lord, he had approached this honorable court earlier.
No.
This honorable court that while declining that he had challenged Section 14 order, gave a liberty to approach DRT.
Go before the DRT.
No, Milord, I am ready to deposit that
You
amount.
may be ready. But the correct forum is DRT. This is not super DRT.
No, Milord, Milord, it has earlier not.
What is that? Your client has not briefed you. But he is producing the order itself.
Thereafter, Milord, the present, the opposite party taken. Now 44 lakhs is pending. I am ready to deposit that amount.
No, Milord, 75 lakhs, 48,300.
As per the account statement, that is under Annex 2, Milord.
Can the bank? Where is your statement of? You give a statement of account.
Today I am deposit 30% Milord, and within 2 months I will deposit the entire amount. Total amount.
What is it?
We'll pass that.
Over, I'll just get
You get that.
Deposit the total amount. This is my only building Milord residential house.
He is helping you. He's so fair and still you want to argue. Yes.
Item 3, WPC 10614 of 2026.
Application, Lord, property was put to auction below. I participated in the auction. I the highest bidder. The sale was confirmed. Thereafter, sale certificate has been issued.
Suggestion is not given.
Yes.
They came out.
Intimated for demarcation of the land. Operate and record. After the bank has also made a decision for demarcation to see demarcation of that.
Which is that WP?
That number and
That WP is here or
yes.
here?
Here.
Got this issue.
Yes.
Issue. Go to the hostage issue emergency notice.
That is very independent.
For demarcation.
That we cannot discuss. That is right. We cannot discuss. You have made a party.
No, I am not, because bank has not given to this.
To facilitate that, there is something to be done by the state authority. Demarcation of the land.
Demarcation.
So I will direct you. We will direct you to impede. You direct you impede.
Yes, yes.
Short grievance of the petitioner is as to non-handing over of possession of the property pursuant to the auction sale in a coercive proceeding for recovery of loan constituted under the provisions of the Surface Act 2000. That Bank Council intervening in the matter on behalf of the OPs submits that even the bank itself has filed another writ petition number, another case in WP number. So seeking a direction to the revenue authority to accomplish demarcation of the land by metes and bounds. First stop. Therefore, in the fitness of things, the arraignment, ARIGNMENT, arraignment of state authorities would facilitate complete adjudication of the list at hand. First off, next paragraph. In above circumstances, petitioner is hereby directed to array array who? Tahsildar.
Tahsildar.
The jurisdictional Tahsildar has to be number 3. This petition. First, if cost title is amended in terms of this order, issue notice to Tahsildar. First, Learned DGA, Mr. Behura is requested to accept notice for newly added OP3. First, okay. Amend the cost title. Okay. You accept notice for whom? What I do? Well, we do the name of sorry. That's what we should do. Yes.
Item 4, 10632 of 2026, 10632 of 2026.
Page 29, Lordship has directed, page 29, madam. 29, my lord. What the last one? In the above circumstances, petitioner is disposed of, receiving liberty to the petitioner to offer OTS, prescribed format for the all necessary requisites, and that a sum of rupees 3 lakh paid on 21/2026 would be treated as the premium for the same bank to take a call upon the subject of
what happened?
My lord. Therefore, my lord, petitioner filed an proposal, my lord. OTS proposal in 9/3/31. 6 lakhs, my lord. In very same next date, my lord, 10th judge rejected on the ground that acceptable offer is not satisfied. Thereafter, after negotiation, the matter was settled between the parties in 9 lakhs. The 35
After rejection.
after rejection.
Rejection was on which day?
Next day, the 10th March.
Then you applied you offered OTS in
9 March. 9 reminder.
rejected on
10th, next date, my lord. 10th March.
Settlement negotiated on
16th, my lord. 14th, he filed the application. 16th, it was settled, my lord.
Again, filed an application.
14th, my lord. 14th.
14th, another application.
Application for 9 lakh, my lord. It was settled between the parties, my lord.
for 9 lakh.
My lord. Thereafter, the opposite party bank not approved the approved letter, my lord. Approval letter has not been provided me, my lord.
This OTS approval subsequently
My lord. Settled, my lord.
that you have not received.
You are for the bank.
Yeah,
What he said.
no, so actually, just he has given me the copy. But English,
Learned panel counsel, Sri so appears for OPs. This matter next week.
Till then, no court action. It is the only residential house, my lord.
right for that, Lordship, as per this honorable.
Pay that money first. 2 weeks they should pay 30%.
30%.
Today I am paying. I will pay.
70%.
My 3 months will be allowed.
70%, 2 months.
30% today, at least within 2 days, 2 working days. 30% within 3 working days. And the remainder within,
2 months.
he says 3 months.
3 months. My lord.
Then it will give interest on. It will give interest on.
My lord.
Alright?
3 months, but the fortnightly installment, because after 3 months, if we default, Miller, then pay using 3 months. Because
That
option
should
notice
be
already issued.
periodic installment.
Okay.
The petitioner being the borrower of a housing loan is knocking at the doors of RINCO for proceeding coercive action of recovery constituted under the provisions of 2002 Act. Sorry. First, learned counsel for the petitioner submits that his client has some financial difficulty and therefore he was not in a position to remit the repayment money in question and that now he is willing to discharge entire loan liability if a reasonable period is granted. First off, they adds that within a day or two, his client would be remitting 30% of the outstanding, and that within 3 months, remaining amount also would be remitted if easy installments are accorded. First off, with this submission, the panel counsel appearing for the bank, although initially opposed, now is agreeable. Subject to the condition, should the petitioner fail to adhere to the proposal, all coercive action should be permitted to be taken. First, with this counsel for the petitioner is also, for the petitioner also partners. First, next, in the instances, petition is disposed of with the following directions. 1. Petitioner shall remit 30% of the outstanding amount within 3 working days, reckoned from this day. Next point. The remaining 70% of the amount shall be remitted an outer limit of 3 months as follows. 25% within 2 weeks, another 25% within 2 weeks next following, and remainder, that is 20% within 2 weeks next following.
1 month, 1 or 2 weeks.
No, of course. 1 second. If a petitioner fails to adhere to the directions above, which are made in terms of, brought in terms of his own proposal, bank be at liberty to take all course actions of recovery in accordance. And in that connection, all conditions are kept over.
Pardon, my lord, direct to the opposite to hand up the key of the house, my lord.
First, you make payment. 30% you pay.
My lord.
One more direction. Above. Right? On a pittance of 30%, as taken above, the bank shall deliver back peaceable possession of the security property by way of permissive occupation, and it can physically take the possession of the property in the event the terms of this order are not. You give 30% he is giving, na?
70%. First default, he should surrender back the possession. On the first default,
We have said you can make.
then definitely we have to go to magistrate, then police, then to take. He has to surrender property. If he is defaulting, then he has to surrender back. If he is taking possession of 30%.
Last time, it is open to the bank to move an application. If difficulty is encountered by in delivering back or taking back the possession of the property. All right, to move application, it will come before us. He knows what to, if it does not give back.
Pardon?
Next.
I beg to pardon, my lord.
But I have filed
May-
the
may-
local
may-
account,
may-
may be recorded.
Huh?
I have filed the local account, that may be
Yes,
accepted.
sure.
I beg to pardon, my lord. I don't know. Till then, no course. I don't know.
Huh?
Till
In the
then,
previous one,
I don't know. Till then, no course.
it only needs to be stated that the course action of recovery shall be kept in suspended animation, subject to compliance. Okay. Next.
Item 5, 10636 of 2026.
This case, the only was taking an overdraft facility. And now I declared NPA.
Would that facility, what is facility went?
In the year 2022.
Date nothing.
No, 18 to 2022. In paragraph 3, I have written.
22. How much money?
15 lakhs, my lord. It was declared NPA on 23/9/2025.
And the petitioner, thereafter, cell notice has been published, my lord. The petitioner has preferred an essay before the DRT and essay is pending, posted 17/4. In between, a cell notice has been published. I have, my lord.
Unless there is halting by the DRT.
Thereafter, I have.
All right, I'll leave argument. How much money you will pay?
My, your lordship, direct 25% is a cancer asset.
No, follow
30%, your lordship.
Well, I want.
let him pay. Rest of the things, the remaining amount, when will you pay?
Well, only 30% that will be decided.
You say this one once for all will decide that no. You can't go on having the installmental basis litigations. Once for all will do of this.
Yes, no, 30%, there
30% within 3 days.
before 15th. Within the date of
All within 2 weeks. 30%. Remainder?
Remain your lordship may fix it because there is a dispute between 4 lakhs deposit rate which has not been taken.
It's the question of account.
Yes, ma'am. Accountant will give and accordingly the lordship may fix 3 months.
Whatever amount is not that you in the pocket of like
Yes, yes, ma'am.
it is paid by the RTGS.
Yes, ma'am.
As the case may be. You give due deduction of that.
Yes,
If
ma'am.
payment is made.
No.
Yes,
Now,
only
within
that
what
after
outer limit? Within what outer limit?
3 months thereafter your lordship.
3 months. With the interest.
Well, 15 days, my lord, because it is going to be an auction on 15th, my lord, 4. And today is, my lord, 9th, my lord.
Ninth.
So by
But within
before
that,
15th, my lord.
within that, 50% of that first 30%, 15%,
My lord.
he will remain.
Well.
Otherwise, he won't. This one.
My lord.
That will be end of the matter.
It is a house in the remote area in the.
Why did you give that house in the remote area? You should have go for
I
it.
have no. I have
Real property you had given, they are going against.
Yes.
Take note. Petitioner, a borrower, is grieving before the court against the coercive action of recovery of loan constituted under the provisions of Act. Next paragraph. Learned counsel for the petitioner submits, and the learned panel counsel for the appearing for the respondent OPs agrees that petition be disposed of by directing the petitioner to remit 30% of the amount within outstanding amount within 2 weeks, of which half be paid within 1 week reckoned from this day, and that the remaining 70% of the amount should be paid in 3 equalized installments reckoned from lapse of 15 days as at 25 within 2 weeks, another 25 within 2 weeks next following, the last 20%, 2 weeks next following. Failing which, bank would be at liberty to take all the coercive actions in accordance with law. And in that connection, all contentions are kept. First, ordered accordingly, petition is disposed of.
Only one line, your lordship. What amount is paid before this taken.
Hardly need to be stated that whatever amount has been paid by way of check or RTGS by the petitioner shall be given due
Okay,
deduction.
yes, but it's always.
But that will be adjusted.
Will be given due deduction. Okay.
My lord, one first 15% by 15, my lord.
No, we
By
say
1
1
week.
week.
One, okay.
1 week.
So there.
Okay. Next.
Till then, no course.
Till next, it hardly needs to be stated that subject to compliance, there shall be no coercive proceedings.
My lord.
Item 6, it appeal 1/4 of 2025.
Lordships, this is a case
Yes,
where,
madam.
yes, Your Lordship, this is a case where from day one, we have been raising the issue of jurisdiction before the council under the MSME Act. And having not taken consideration, they went forward without we having an opportunity to take part in the conciliation and arbitration, completely in violation of the Act. And in such a scenario, Your Lordship, the Supreme Court also allows for entertaining writ. And we've gone through Your Lordship's judgment.
in our judgment.
Yes, your Lordship.
We have considered the apex court judgment and then we have made.
Your Lordship, the Jharkhand judgment has not been considered. In fact, factually, we are very different. What your Lordship said in the judgment is, what the petitioner did there is, he did not raise the jurisdiction point. He withdrew, and then again, after a 1.5 years, again came and filed the writ. We probably fall a little different. Your Lordship, I made a small date chart for the foundational facts.
You did. What is amount involved?
Your Lordship, 45 lakhs, and then the interest amount is very high. Your Lordship.
How much?
That will be a compounding interest.
Total amount, how much? Award is for what?
Award has been principal 45 lakh 60,000
Plus
and interest which would be, your Lordship,
at 18%, commercial is 18% max.
yes, your Lordship. It would be your Lordship, the compound interest with monthly rest to the supplier, and it will be according to three times of the bank rate notified by the Reserve Bank.
3 times of bank rate. And Parliament says that, therefore we cannot question that wisdom of the.
Your Lordship, and we had filed the writ petition even before the award went to
give the foundation facts. But
yes.
how the
Your Lordships, actually a reference is made on 27/3/2006. That is, yes,
by the council,
by the claimant,
to the claimant,
to the council under the 1993 Act. That means prior to the 2006.
the 1993 Act.
Yes, Your Lordship. We have a copy. Your Lordship, I have a copy.
I do not.
I have a copy. I would have a copy too. I would have extra.
Just on delayed payments to small scale.
Yes, Your Lordship. Now this, I made another copy of it. Your Lordship, the strange thing about that act is it did not have any territorial jurisdiction clause. So it will be by the normal CPC thing, or looking at every aspect. The contract involved here does not have an arbitration clause. But all the jurisdiction was for for Bhubaneswar, the civil courts in Bhubaneswar. The entire cause of action, all payments in state of Odisha, everything has been done in state of Odisha. So after they made this, filed this claim application in Thane, it was an incumbent on the part of that very council under 1993 Act that before receiving whether I can actually receive this or not. They did not do so. They kept quiet. Then what they did is,
repeat.
Your Lordship, when they received that claim application under the 1993 Act in a council in Thane in Maharashtra, it was incumbent on their part to see whether they could have entertained it in view of the cause of action was in state of Odisha. They did not do so.
If the jurisdiction of the court is not cause of action specific, there are such laws.
Yes, the entire provisions, general provisions which are applicable in CPC, that is what is the only thing that could have written.
Whether any provisions is
No. That's been our contention.
Is there any provision which excludes CPC?
No.
Either this also is not there, that also is not there.
And Your Lordship, what?
Let us see. Let us
Yes,
explain to us the thumbnail description of that.
Yes, sir.
What are the provisions? How it operates? What is the objective?
Your Lordship, this objective is more or less just like the 2006 Act. It is on the supply and services. Your Lordship will find the section 3 is liability of the buyer to make payment. 4 is from where the rate of interest will be payable. Compound interest, recovery amount, 6 is where they have the arbitration clause. Here there is no conciliation provision, Your Worship.
That is one difference.
Yes.
Recovery of amount due.
Yes.
Amount due from there together with the amount of interest and suspense purchase of section 4 and 5 shall be recoverable by the buyer from the buyer way of a suit or other proceeding at end of the time being given.
Notwithstanding anything contained in
Anything contained, party to make a reference to the industry for acting as an arbitrator. Where is the requirement agreement?
No, not required.
Not required.
I'm just saying the facts of my case.
Huh?
I was narrating the facts of my case.
So, under 6(2), it is a compulsive arbitration,
Yes, Your
regardless of the class.
Yes, just like the 2006 Act, which is also compulsory. Yes, compulsory.
So, how it respect of matters referred to in that subsection, provisions of Arbitration Act 96 will be applied.
We apply.
96 excludes CPs.
Yes, but only because there is one for the jurisdiction point, it absolutely CPC. I would say 96 Act.
Yeah.
But Your Lordship, the thing is, when they made this claim, there was no analysis as to where it is to be found, where it is to be filed, and the matter was kept like that. We did not know that the claimant filed because the work was over since 1999. Now, what happens is the new act comes into force.
Whether new act makes
Yes.
a new regime applicable to pending.
It says that it will be continued as if it is under the new act. But there is one we have in this. The case that we put forward before the writ court was this, that if something is not validly initiated under the old act, that cannot be said to continue under the new act.
Does it mean that it will continue under the old act only?
No, I say that it would not have, in the situation that we want to formulate is this, that Thane should not have entered.
On what basis? You are saying it thrice forth, you are saying it true.
Yes.
On what basis? See, subsection 2 of section 6, the provisions of CTC, because it internalizes the provisions of 1996 Act.
Yes, Your Lordship.
If that is so, where is the idea of territorial jurisdiction?
Your Lordship will see the idea of making a claim, and thereafter comes about the arbitration.
How courts have interpreted this subsection 2 of section 6, various high courts in the country?
Your Lordship, no, we haven't, I'll be very honest, we haven't got a judgment right on this proposition that we are making. I'll keep, but Your Lordship, this proposition I'm keeping is, I'm actually narrating more factually and legally narrating on that. Your Lordship, that after the new act came, we got notice. We got the notice after the new act came. Your Lordship, the new act came on November 9th, 2006.
Notice might have been issued to you.
Sorry, 2nd October 2006, the new act came.
Came on
Yes, that's there in the date chart, the second serial.
October 2nd.
Yes, October 2nd.
On Gandhi Jayanti, it came into force.
The new act, 2006 act came into force.
2/10/2006. Notice was dispatched from their office when?
Your Lordship, we received it on, it was a notice dated 9/11/2006.
9/11.
2006.
There are two judgments of the Apex Court. Where are my notes? Go to the J series. The Apex Court says the law as on the date of institution of the list of the dominant lists will apply.
Lordships.
So when they directed notice, when the and the postman brought that notice to your house, that is all irrelevant.
No, Your Lordship, the relevance of that notice is this, that in that notice they refer to the 1993 Act and clearly stating that we are heading for arbitration. That is the tenor of that notice.
Right.
They were very clear about it.
Correct.
Then
Now, old act only.
Old Act.
Correct.
Now, Your Lordships, we asked for 2 months' time to know that what this is, like to gather the papers and to know what this is. Then, Your Lordship, literally the body was defunct. Nothing happened till 2013. In 2013, we received our second notice.
What did you do?
Your Lordship, we asked for 2 months' time, to which there was no reply, and the body was complete. It was defunct because, Your Lordship, this transition which happened. Most of the part of the country we had this issue. That literally it was defunct.
How this argument is treated by the next witness?
The single judge has taken note of that.
Let us see whether it is right or wrong.
Yes, Your Lordship, if Your Lordship, if I can just put all the foundational, then it will be. Your Lordship, the second notice was clearly under the second act, under the 2000 Act. And
Where is that order sheet of the council?
I'll come to that. Your Lordships will find that the second notice will be page 117 of this written.
Was there any order by the council saying registry should issue second notice under the new act? Where is that order? Registry on its own, it issued like that.
On its own.
No, that makes no sense. That will not add any merit to your case.
So, Your Lordships, no, what I mean to say is that this is the notice which was issued. We went there, and the first objection that we filed was on this.
Therefore, we are asking,
Yes.
where is the jurisdictional point? Always earlier, 1950 Supreme Court, Kiran Singh versus Chaman Paswan, 1954 SC 347, something like that. Judgment. It treated pecuniary, territorial, subject matter jurisdiction having to root of the matter. But
Lordships.
thereafter, pursuant to recommendation of the law commission, there is a shift in the view. Only subject matter and pecuniary will go to the root. Territorial will not.
Will not. I agree. I agree on this, Your Lordships. I agree on that. That's why I'm saying I
Unless
know that.
you show release.
Your Lordships,
The CPC is amended.
I'm aware of the change in case laws also, Your Lordships. That's why I said this is just a fact that I'm placing, not really the main point on which I want the invocation of this jurisdiction.
Yeah.
Now,
Your first point is the Maharashtra Bombay Council should not have acted.
It should not have acted. At that point, we took, Your Lordships, after getting the second notice, we immediately filed our objection. And we filed our objection, at least Your Lordships, first 2 pages were on this jurisdiction issue.
No, whether law prescribes any limitation period for filing objections.
No.
26 Act, na?
Your Lordships,
26 Act takes care of that.
I'll come to that, Your Lordships. So here, Your Lordship, what happens is, after they receive this objection, they do not hear me on that jurisdiction. I may have raised an absolutely wrong jurisdiction. Maybe it does not have a basis.
Now you convince.
What they did is, Your Lordships, they went forward with the proceedings. And 2 proceedings were conducted to which we had no notice.
Wait, no notice.
No notice.
You appear before the court and
No,
you should have corrected the generator and
The
system not.
they are not, Your Lordship, the first system is now they're acting under 2006 Act.
You have said that now.
Yes. So 2006 Act, and the first is that they have to do conciliation. So there was no notice that hereby initiating conciliation. Let that not be so.
Where is the question of conciliation? If the institution of proceeding happens under the old act, how are you going to do that? If at all new act applies, it is only subsequent to that stage.
Now, Your Lordship, what is happening? What has happened is they did their conciliation, to which we were not noticed. Now, Your Lordship, that order says there's only one order that we receive.
Assume that there is no conciliation.
27/1/2014, we received an order sheet dated 18/1/2014 that we terminate the conciliation. You did not participate, we terminate. And hereby we will proceed. So, Your Lordships, and then on 30th/1/2014, again, Your Lordships, Referring to that 18.1, another order sheet comes to us saying that you have no jurisdiction issue. They don't really discuss it. There is no jurisdiction issue. No grounds. And we again terminate it and arbitration starts. My Your Lordships, we appear next date. They say no, nothing doing. You just sit together, that records, and just amicably. So the tenor is still in a conciliation mood.
No, this is orally. We were not there. We were not there.
No, that is recorded. That is recorded.
Sure.
That is recorded. That would be 151, Your Lordships.
It goes to what letter is, that order is contrary to the tenor of your submission.
Petition, respondent, advocate are present for the hearing. Counsel heard the both counsel and advised to solve it amicably and inform the counsel accordingly. Now, Your Lordships, if they had entered into arbitration, we agree that because the prior date is the prior order is arbitration. Then, according to Section 23 of the 1996 Act, what is that has to be filed is a statement of claim, and we get a chance to file a statement of defense, putting all our witnesses. But at this stage, this is what happens. This 15th March 2014 sitting never happens. And Your Lordship, what happens meanwhile is we keep please kindly give us a detailed reason on the jurisdiction issue. Because if I have a legitimate jurisdiction issue, then I cannot even participate in the constitution.
No convincence.
Now, Your Lordships, what they do administratively, they issue an order, which is there in the next page, saying that they write some notification of the Maharashtra saying that we have jurisdiction, not really.
You convince us. Now, I assume that they have not decided jurisdiction.
Yes, Your Lordship.
Where is the jurisdictional issue?
Now, Your Lordships, what happens is when we challenge this jurisdiction issue before the writ court, and we inform them that we have filed a writ, what they do is in the next day they pass the over, which is literally, Your Lordships, 2-3 paragraphs.
Was there interdiction by the report?
It have happened, the award is passed.
Very big stay.
Yeah,
You will file writ petition and sleep over the matter. Whether the other authority should also sleep over the matter. No, that is very object. Kindly see the interest, madam. Madam, kindly see the object of 1993 Act. It appears to be draconian provision. But in the wisdom, in the accumulated wisdom experience, the parliament has enacted.
yes.
Object is to boost the industry. Otherwise, the money will stagnate somewhere, eventually resulting into stagnation of the university.
Lordships, may just bear with me for a minute, Your Lordships. May just look at the face. The face of the award is simply this. Even if I did not participate, I had filed an objection application. Not a single word of it is taken into consideration.
What was the objection you had?
Your Lordships, in detail in the...
Let us see. What is the objection? When did you file? You filed the objection when you received first notice and when you filed the objection. Let us see whether objections are in time for this.
First notice, which comes under the old act, comes on 9/11/2006.
9/11.
Then it was totally different. The second... nothing happened in that.
No, conductor. You have notice of this. There is a proceeding pending.
We do take a time.
Where is the copy of the notice? Let us show the copy of the notice. How the notice. You are not some agriculturist, farmer, or a CBC, or a person hailing from rural area. You are doing business. Therefore, presumption is you men and men.
Your Lordships will see page 116.
Page 116.
Yes, Your Lordships. And I'll show second notice, which can clearly show nothing is transpire in between.
Above him, the applicant has filed an application as per copy attached praying for leave as mentioned. This is formal acceptance of this application with the Council Imports Regularization Commission. So it acts as an arbitrator and so rules made that whereby projects of 7 of arbitration and 26 becomes applicable. They have said that this notice is accordingly issued. You should file a duplicate or duly verified reply along with copies of documents on which you intend to rely within 30 days. The date of when did you file your Objection.
Your Lordship, we sought for a 2 months time against.
There is a provision. To give 2 months. Otherwise, it parties the character of a suit. The object of the act is to exclude the civil courts.
Your Lordship, may I
They
just?
are unhappy. Parliament is unhappy with the court.
Your Lordship,
Therefore,
we
created-
did ask for a time. There was no response from.
They
this
need not
body.
be.
There was no
Unless you
response.
show. No question, madam. Where is your right to see time?
Your Lordship will see, had the body moved, the second, your Lordship will see page 117. That's all that has happened
Once
in the before
on
the body.
9/11/2006, notice came to you.
Yes, Your Lordship.
You received it on which day?
Your Lordship, let's assume within 7 days. I
No, not
take
yet.
that
Not
assumption.
yet. Not
I
You
don't
have to
have
say the
anything.
facts. See, matter will not rest here. Seeing the enormity, we assume it will not rest here.
Lordship.
Therefore, we have to make a bandobast judgment. Give us the facts. You received on which day?
I think Your Lordship, 17th November. 17th November. There's a stamp there, Your Lordship. 17th.
17/11, you received.
17th.
It said within what period? Within 30 days, you should have filed.
Yes, Your Lordship.
When did you ask for time?
Your Lordship, we asked for time.
After the second notice.
We asked for time immediately.
Which day you asked it? How?
This is 13/12/2006.
By that time, 30 days were already over.
Yes, Your Lordship.
Whether this 30 days is the time prescribed by the council or by the law.
Your Lordship, it's absolutely silent on this.
Then 30 days means 30 days.
17.
No, that is applicable. No, 96 Act is applicable. Within what period they have to file?
30 days, yeah.
Within 30 days.
Now, Your Lordship, nothing moves thereafter.
Not moving.
Your Lordship, he filed the time petition within 30 days. Time petition was
If you
filed within
received it 17th/11, you have filed it on 13th.
13/12.
What was the mode of sending? How did you file it? Physically or by sending?
Where have you sought for a time?
That's not a disputed fact.
No, we want
both
to know.
sides.
We want to know. Where is the question of dispute? Because other side is not here. Now, the threshold we are asking, when did you send that application and how? Which the postman carried that?
Registered post, Your Lordship.
Show that.
But I do not. But it was not in dispute, Your Lordship.
We are disputing. We are disputing because the object of the act is speediest recovery of the money to the exclusion of the civil court.
Your Lordship, look at the second notice, Your Lordship. Nothing really happened before the body, which will, Your Lordship, see 117.
Anything in the portal, in the well-versed.
There is a receiving of notice of this. There is an evidence of receiving that.
That on, received on,
In 2006.
21.
12.
that is beyond 30 days.
They have issued it, they received it on 20.
When you issue from one corner of the country to another is not the question. It should reach that one. Then Allahabad High Court has said that law of notices, but be Mujumdar, says like this.
Lordships will kindly bear with me, Your Lordships. What happens is nothing really moves. The body shifts to the 2006 Act.
No, in that case, what will happen, madam? You have to into your conduct. If you say that there was nothing put there, but have you conducted yourself in a manner? Then we can say.
Your Lordships, undoubtedly, we had sent them, we had asked for 2 months' time. There was never reply,
Then
no notification of the next date, Your Lordships.
did you?
Yes, Your Lordship.
When did you
This is
file?
there.
When did you file? No, not application. When did you file your reply?
Your Lordship, after the second notice. We reply after
Second
the
notice
second.
was issued to you when?
It's 23/5/2018.
2018.
13, sorry, 13.
2013.
13.
So by that, already, how many years were over?
Your Lordship, we had short time. There was no next
You said
date,
that.
Your Lordship.
You said that.
There was, because the body was not functioning, so we were not sitting only.
They were not sitting on it. But from your side, the Arbitration Act fixes what period? Just tell us, within what
Your
period you
Lordship,
have to pay?
Your Lordships, now the whole that I ask myself is this. If they are moving under 1993 Act, there's a different understanding. If they are moving under the 2006 Act, which they have moved under 2006 Act, then Your Lordships, when initially a claim application is filed, I did not file my reply. What we have to do is to do a conciliation. Because under section 18(1), 2, Your Lordships, the first thing that happens is conciliation, Your Lordships. Arbitration does not kick in at that time, Your Lordships. And any material filed in or before conciliation cannot be used as part of the arbitration because the Arbitration Act itself prevents it. And in fact, it's one of the ground for section 34. And that's exactly what the Supreme Court says, Your Lordships.
Did you go to 34?
We did not, because the moment they rejected our jurisdiction application, we came before this court. And then we amended when the award came, Your Lordships.
The single judge said even not go to 34.
There is a Supreme Court judgment, Your Lordships.
We are asking
Yeah.
what the learned single judge said.
No, what the learned single judge did is that he said that all the questions that you are raising here, you could have easily raised in 34, but gave a finding on it.
No, but now we will say, regardless of the findings, you go before the 34 court. That is the objection. Huh?
Your Lordships may say that.
Yeah. That's good.
And the period will show a judgment of
We
Supreme
cannot
Court.
extend the.
Your Lordship, no.
This pendency can be discounted.
The whole period is least pendants. Your Lordship, the outcome came when they first reached.
14.
Yes, and the
Other limitation is not
also
applicable.
covers it.
Section 14 is not applicable. The arbitration.
Your Lordship, that is not.
Section 14 is applicable to 34.
What it says, Your Lordships, is this,
34.
that for 34, only section 5 is not applicable.
No, that finding.
Judgment.
34. No, Mr. Bevara says something has to be sensible.
No,
Because
section-
whatever
Number judgment. Our High Court has several judgments.
It appears to be sensible.
It's very well clarified, Your Lordship, that section 14 of the Limitation Act is applicable. Did you? I wouldn't think.
Otherwise, it is 90 days. No, 90 days is one thing. Discountable period of 14 is another.
Exclusion.
Exclusion. This is exclusion.
Okay, Your Lordship. Before the award,
Award is dated.
award. Award is 3 February 2015.
Especially if the new law says proceedings shall continue under the new act. Then lot of issues to the painted. This intra-court appeal with the sufferer of the appeal. See, okay, see. Any other point you want to, whether we should treat all the points, it will be on merits only. Then we will take that point. Otherwise, now we say.
We have an issue. Lordship's proposal is actually the best proposal, but I cannot say anything. Yes, but Your Lordship, all that we want, the single thing should, we'll raise all the points there.
We agree. Kindly be seated. Appellant, a company incorporated under the provisions of the Hon'Ble Companies Act 1956,
is preferring this intra-court appeal for laying a challenge to learned single judges order dated 18/6/2025, whereby its WPC number 6 of 2014, which called in question the MSME Council Award dated
23rd February
23 to 2015 has been negatived. First one. Next one. Learned senior advocate appearing for the appellant very vehemently argued seeking invalidation of impugned order of the learned single judge and also the award in question, drawing attention of the court to the provisions of 1993 Act. So 1993 see this act, 1993 Act. Sit down and look. And also the new regime brought about by 2006 Act, MSMED Act, that came into force with effect from 2/10/2006. First time. Next, having heard learned senior advocate for the appellant and having perused the appeal papers, we decline indulgence in the matter inasmuch as the appellant has got an alternate and equally efficacious remedy under Section 34 of the Arbitration and Conciliation Act 1996, which is internalized both by the 1993 Act and 2006 Act. First one. In fact, learned single judge, while negativing the challenge to the award, which paragraph says 34? At para 20 also has discussed this aspect of the matter. First one. Next paragraph. For each of reference, para 20 of the impugned order is reproduced below. Next paragraph, one more point. The vehement submission of learned senior advocate Swami Ratho that relegating her client to the statutory remedy under Section 34 of the 1996 Act would not do justice to it, inasmuch as the findings have been recorded on merits of the matter, need not be much adverted to, inasmuch as when a writ petition is negative on the ground of availability of alternate remedy, observations that are made in the order negativing the petition cannot be construed as the findings that would bind Section 34 court. First, therefore, that apprehension may not be. First, now being said, one clarification needs to be made. But yes, to the effect that whatever period in prosecuting the writ petition and the writ appeal is liable to be discounted in terms of Section 14 of the Limitation Act 1963 for while computing the period of limitation prescribed for laying a challenge to award of the kind under Section 34 of 1996 Act. First, with the above observations, this appeal fails.
Your Lordship, can we make a small prayer?
Yeah.
One line that the observation of the single judge, anything shall be taken into note by the 34 court. That would be findings, Your Lordship.
With the observation that the observations of the learned single judge on merits being confined to disposal of the writ petition shall not influence the trial and disposal of intended Section 34 appeal. Is it appeal or suit?
No, it's
Appeal. This is appeal. Section 34 appeal. Section 34 proceedings.
Proceeding. It's actually not an appeal.
You have won the case now.
Yes. You have made it easy for.
Yeah.
Item 7 has been adjourned. Item 8.
Little modification may linguistically undergo after we. Okay.
Item 8. WC 8717 of 2023.
236 it is. So kindly, just one short pass on behalf of the learned senior.
Once time because you are running into 236 pages.
They have just given 31st March.
How many days you need for reading 236 pages?
Well, at least 2 weeks time.
Every morning one page and evening one page. Is it that way?
Not that way, but we have to correct the materials and to take instruction from the client. So that is why
There's only one.
Next week you do.
Lordship, there is only one interim application. I pray for one short pass over.
Interim application for what?
Is the because they are continuously charging the delay payment.
that is
That will consider
that
when
is
the
the
main
part.
magistrate.
That is the part.
How does it? That's one.
only the next a week after next.
Next week at the request of the counsel appearing for the respondent.
No. Whoever appellant, whoever petitioner. It is
The request of petition.
Your Lordship kindly. Kindly a week next.
Lordship, only one date may be fixed.
It will come next.
Item number 9 has been adjourned. Item number 10. WPC 24919 of 2024.
This case is also squarely covered by one of my lord's judgment. Yes, I have given you. Mr. Rai was here.
Bhavani Shankar Rai Guru.
Yes, he was here, perhaps he's sitting outside. Yes.
Yes, sir.
And I have given him the letter, I have shown him that. Also,
Yes. Have you changed
only 2 changes are required. I have just,
the
I can put in place, his name will be.
yes, just whatever. And so that will be taken in the evening today.
My submission be recorded.
But I just
The stand taken in your counter.
is dead.
Let me clarify that point. My lord friend is what has happened. Original application filed before the tribunal. 3 original applications were allowed. 1 original application was dismissed. 3 original applications which are allowed, that those cases were challenged here by respondents. Your Lordship dismissed them. Thereafter, the Honorable Supreme confirms my Lord's order. The case which was dismissed by the applicant's case which was dismissed That was before my lords, and your lordship decided in my favor. That I have given their judgment.
Then what to be considered?
And the name appears in the same zoning.
Because all
Submission be recorded.
In paragraph of submission,
And page
is
26.
also there.
yes, in paragraph.
All right. Submission will record.
20, no, page 26 of the counter. By the this month.
Paragraph 4, your lordship.
The contractor, that is a contractor, casual vacancy.
Not part-timers. They are not part-timers.
Yeah,
Yeah,
casual basis.
Casual employees.
And that AJ, instead of AJ, your lordship. CG, perhaps he is CG. Senior panel.
Page 26, para 810. Page 26 of the petition.
Only this correction is required. Absent. Only one.
No, even his submission also did not take.
And only correction will that. In place of 1 to 1995 and paragraph. In place of day,
That becomes 1 to 2006.
5.
5.
Man.
5 it is. Yes, sir.
And in place of they, it may be he. Because this is a single person. Yes, ma'am, the 3 applicants.
So, your name is correct, no?
Yes, ma'am. And I.
Where have we stated a confirmation of order by the apex court?
That I have, in that lordship has not
mentioned.
Not mentioned. In that memo, I have given that order of the Honorable Court. Earlier, I have filed that.
That may be added, my lord. So that it is.
Where is your memo, brother?
That it was given on 20th November 2024.
Do you have copy?
Yes, ma'am.
Please, once we will give back that also. Above 9, between 8 and 9. 8 and 8. You make it 9 and 9 becomes 2. 1 and 2. It is relevant to mention that the order of the coordinate bench in WPC number 11669, etc. of 2017. Disposal of on when it was disposed of 8/8/2017. Correct.
Yes, ma'am.
8/8/2017. Having been challenged before the apex court, in SFP number.
Hello, Your Lordship, I noted down that 11671. Your Lordship wrote down that 19165 of 2018.
19/9/2018. That was disposed upon 7/3/2019. 7th March 2019.
2019.
And confirmed in SLP number
Carried to the apex court in SLP number 9477 of 2022 that eventually came to be negative. While order dated 18/7/2022. First off. Thus, the views of the court have received imprimatur, and therefore the finality from all angles is attached to the same. First, the contentions now urged on behalf of the other side, if accepted, virtually amounts to sitting in appeal over the views of the highest court of the country, and therefore are rejected. Right.
Only I want to bring my Lord's notice with that in those cases your Lord's allowed that was dismissed by the tribunal. Here, my Lord, this has remanded. So I am against the remander because of the filing of the counter. They have remanded to dispose of the repentance. Against that I have, unless I have to this fact I have to brought to my Lord's notice.
May not be.
No, I want to.
In earlier case, it was dismissed by the tribunal.
Yes.
In this case, it is
Remanded the matter for
That's
Your Lordship, I see, pardon me, item number 8. This is a matter on the last occasion when it was listed without informing me that I took adjournment and I had brought it to your Lordship's notice. There is IA, interlocutory application of 2020, which is pending. By that application, I want to bring to your Lordship's notice that the interim order passed by your Lordships have been frustrated and 2.73 crores of a sick unit has been illegally appropriated by the man. I only pray the IA be listed next week. Let the IA be taken up, let the replace wherever.
But your friend
I will inform you. Okay.
Number 12. Just served a copy of the objection. This matter will be taken up any other day. Next week. Yes. 12 next week.
Yes, brother. Single bench matter, special adjourned to 20th of that on that day, unfortunately, bench could not function. There are 2 Friday not declare holiday. Only tomorrow, matter. Special adjourned to 20th March.
Single bench.
Yes, only same.
There are 60 matters already.
This is the execution case. You must remember that early disposal of the execution case is also directed to personal appearance.
Personal appearance.
Therefore,
Both cases.
Personal appearance.
Yes. This is the personal appearance. Order was there.
There's both cases, my lord.
Put remove 3 and put this 3.
The two cases, my lord.
Item 13, Rate Appeal 208 of 2024.
My lords, this is a case.
If Behra smiles, then he should.
My lords, seems to be covered, but here we had a point. There was it is a project funded by the World Bank, and it is not a sanctioned post.
We have considered that object also. That also we have considered.
But
In 2-3 judgments, we have considered this aspect also. In one matter, very vehemently.
yes.
But I cited that Dandakarana case. You
Yes,
have
I-
cited that.
Have you changed everything here? No, identical matter.
Identical.
No, the whole concept is that if the threat gets over, have they been
Given away.
given away? If that is not, and they are still continuing.
It should have been absorbed in some other government.
That is the idea. Idea is
Having
small people. They do not have political influence, but nor riches, nor property.
Whether
Not
that
in- all
Dandakarana
that-
case has been overruled specifically overruled. That is the question. Dandakarana still holds the field or it has been specifically
no,
overruled?
after this.
Conflicting judgments. That's for where.
Yes.
Item 14, Rate Appeal 171 of 2024.
14, my lords, let it be taken up any other day. I have not gone through the brief.
He wants to, we'll have it next week after next week. Next week? Next.
Lordship, they will let me know.
Let him look into.
Yes.
Item 15, Rate Appeal 327 of 2024.
This is
Seven.
your lordship.
This is good.
Covered.
Useful.
That is an advertisement.
This is the-
Copy.
Give copy. You should always share a copy with the government advocate. Already we fall upon them and they will be in a very disadvantageous position. He has corrected it also. He has corrected. Have you given the corrected copy to him?
Only petition or revision. And
Same. All these conditions. Okay. Okay.
Item 16, Rate Appeal 1274 of 2025.
Yes.
There are 3 cases that is Rate Appeal. Here we are concerned with the regularization of the petitioners. Under the bank, those who have put in 30 years of service. The big background is some memo of citation is and memo of citation.
matter is in next.
No, that is in contract matter. We are on the other 2 matters. The last occasion also, number of times.
I'm not taking time.
He's asking. Even password.
I'm not taking time. I'm only asking for password.
Password also you will not give him.
But let me just summarize it in 5
He
minutes.
is upset. Argument is for us and for the other side also.
But that's one,
Because he has to meet it.
one case has been.
Call next week.
No, but I'm sorry, my lord.
We don't have.
But I'm sorry, my lord. I just 1 second. I just. No, my lord. I'm sorry, my lord.
We have said, we have said.
I'm sorry.
Over.
I'm sorry, my lord. One
No,
word.
no.
One word I wanted to express. No, not that way. My lord.
That you are saying.
No, my lord. Sorry, my lord. Sorry.
I'm wasting the time.
No, not 11. Your lordship has fixed up specifically at 2 o'clock. So my apprehension was that if possible.
Every time, sir, we are seeing you, our interaction with you, our interaction is not pleasant with you. Although your interaction appears to be pleasant. We are sorry.
we don't entertain. Otherwise, we'll send it to some other way.
No, my lords, my lords,
Matter before some
my lords,
other-
no, my lords, my
where
lords,
he can
no, my
be
lords,
arguing.
no, my lords, I'm sorry, my lords, I take back my words. My lords, your lords will take it up today. Specifically, if your lords will kindly.
Said, kindly do not disturb. Yes, next week.
13 read appeal 1367 of
Courteous
2023.
to the members of the bar. Yes.
Item 17, I am for the respondent and so on. For the respondent and so on.
Pass over.
My lord.
Okay. Pass over.
Item 18,
Item 17, can it be after lunch?
After lunch? No, no problem.
We just, yes, why not say,
See, we told you two options we gave.
my lord.
We wanted to send you to the other bench because we are not that pleasant with you. We are also saying,
No, we folded it.
We don't-
Why not, what I wanted to only suggest, he is praying for a passport, it is okay, my lord, so I am not objecting to that.
we do not want to take this matter today. Can you compel us?
I cannot complain.
Leave it then. Yes, next.
A specific date next week, any?
Next. See, you should always understand that we judges work under the pressure. And we will not buckle to any other tactics. This you should have in your mind. We have seen many people far larger than you people. Don't do that. Next.
Madam, can I play something maybe brought up on record?
Whichever order you want.
The memo may be kindly brought up on record.
No.
I am filing it today.
Yes.
That may be brought up on record.
Okay. Keep dispute of matter.
Pending matter, item number 16, which you are not
Signing it here. You can file it in the register.
1-6.
Item number 16, which you are
No,
not.
sir. Item number 16, we have adjourned to next week.
I want to bring this matter or some matters on record, some memos that can be.
You file it.
Yes, I am bringing it on record.
Take that.
I'll send the copy.
You copy the other side also.
Yes.
item 18, read appeal 1403 of 2025.
Yeah. Mishra is here why?
Sir.
You're here why? In which matter?
Sir, that item 16.
1-6.
I was thinking about this.
We were very told. But sir, he started arguing the matter.
My friend is young actually, he is quite successful.
Sunday, no problem. Are you in the matter?
Sir, I am ready, but actually one problem is there. You know, so you can hear my voice.
He is not well.
100% is fit in fact.
Well, it's only this thing brought up on record. So now both parties present. Serving a copy of the bank to the bank also. That copy, two memos I have been filing.
Counsel for the appellant has filed certain documents along after serving copy thereof on the other.
I would copies out in the court.
The same was taken on with this matter. So next.
Item 18,
Memos have been.
Two memos. Two memos. Take them. Two memos. Take them.
These are the records of the earlier case. That may be recorded.
Next.
item 18, read appeal 1403 of 2025.
Yes, sir.
My lord, I am a party in person
Okay.
for CPSCSI 2024.
What is that?
CPSCSI Combined Police Service Examination 2024. Examination 2024. There is a recruitment in 2024, but their examination is still not held. And we have challenged
This vacancy is against advertisement against 2024.
24.
But examination
It has not completed because there is a high corruption and a CBI investigation is going on. We pray for a 4-year age relaxation in the single court, and government accepted that make a recruitment since 6 years. Last the recruitment came in 2018.
Oh, again, there's an advertisement for that.
No
Any
advertisement.
decision has been taken.
3-year age relaxation already given.
No, 3-year age relaxation, but you are saying that that examination has been postponed because of the
temporarily shifted.
All right.
Temporarily
Has it been
shifted.
taken up again? Has it been taken up again?
Again.
Where is that advertisement? Where is notice?
My lord,
When it will be taken? When it will be taken?
it will be taken very soon, my lord.
Yeah, use.
And there is a 3-year age relaxation already given.
This time it may have that the age relaxation which has already come in the notification, 40 may come.
No, my lord, they have in police service, they are only given 25 is the maximum age limit.
Right now we do not know. After this,
After fresh notification,
we can only
in the event they did not give you age relaxation,
No, my lord, they have already given 3-year age relaxation. My prayer
the
is...
earlier one,
the earlier one.
2024.
No, my lord.
After also.
That recruitment is in 2024. That recruitment is going on, not completed. Recruitment they have not conducted the exam.
Postponed because of the CBI inquiry.
CBI inquiry.
So again, there will be a notification or not?
No notification.
When the examination will be?
Then they have conducting the examination very shortly.
Any notification is there?
They have all.
How could you say?
Said released that previously the examination was conducted by the OPIB, Odisha Police Recruitment Board.
Right.
But now they have instructed that a new board will be formed for conducting of
What is that?
examination.
Instructed means to whom?
Odisha Informed Services.
Where is they instructed? Where from you?
A gazette notification has
There.
published.
Have you filed it?
My lord, give me some time. I will collect.
Otherwise, it will be premature.
I will collect the information. That
See, your grievance is essential.
age relaxation.
Age relaxation.
Yes, my lord.
That question arises when recruitment process begins afresh. You said this recruitment process is going on.
My lord, they
It
have.
is not yet closed.
We have already challenged, my lord, when the recruitment come, but they have already age relaxation. But our prayer is they have similar situation in PMT driver. They have given 4-year age relaxation, and in constable they have already given 4-year age relaxation. My prayer is instead of 3-year, they
4 years should be.
4 years to be, as they have given it already in PMT driver case and Odisha Police District Constable case.
This, which is the post to which recruitment process is going on.
Sub-inspector, assistant jailer, combined recruitment, my lord.
But those they have not given. They have given only for constable post.
Constable post, they have given 4-year age relaxation. PMT driver,
But not to the inspector.
inspector, they have after we making case, they have given 3-year age relaxation.
No, in the judgment, the Honorable Single Judge has granted that also.
3 years.
3 years.
But in
That he is against that.
Against that, he is seeking another. That is a legislative domain. It has to be amended act. There has to be an amendment to the act. Rules.
Power to grant relaxation.
Yes.
Under which power you are exercising?
Legislation is there below.
Which is the legislation? Thousands of legislations. Which legislation gives power? Whether it is in exercise of executive power or statutory power, which is that power? If age is prescribed, age limit is prescribed by law,
Statute. Yes.
then by law it should be changed.
Yes, exactly.
We understand. But if the age limit is permissible under the law, then he may have an arguable case. If age limit is prescribed by law, saying that for all candidates, no candidate shall be above the age of 35 years. No further provision.
That specific statute
Gives the power to grant age relaxation.
Yes.
Then whether that exercise is right or wrong can be examined by the court.
Yes.
Which is the provision. That's the only case now. That's the only point he is arguing.
Yes.
If you have occasion, we assume there must be a provision
which empowers the government to grant the age relaxation.
The Odisha Civil Service Fixation of Upper Age Limit Rules 1989.
Which is the rule?
Sir, my lord, in civil service, they have increased the upper age limit.
We have said it half a dozen times. Which is that provision? We just looking. Here, call this matter. We come to next. Which place you are coming?
Sir, from Google, and there is some medical emergency in my mother. Specific date, my lord. In next week, a specific date, my lord.
Yes, 30th of April. In the meanwhile, you collect all documents, whichever document you want to give us.
Another point, your lordship directed into array 455 numbers of opposite parties.
We examined that. That what to amount to saying that go home without an order.
That
who is aspiring for a job. If we ask them to do impossible thing, they are unhappy with it.
Not that effect.
There is an order. No?
Yes. That is order dated
24 July 2009.
Yes.
No, thereafter 5 to 20.
5 to 2025.
We made an order. 14 persons, 2 to 445 were arrayed as pro forma party that they are neither necessary nor proper party.
Rajia Begum case.
Therefore, he seeks leave of the court to disarray them to the cost. Here, find a memo that affects the open. Yes, in view of the same party is disarray. What is the question of taking this? Earlier order you are seeing.
Earlier order.
No, we have changed that.
But now, are they not be prejudiced by?
We do not. If age relaxation is granted, Justice Ramajoy says in his famous book, Services Under the State, in matters of age relaxation, others are not necessary parties. There are 2 judgments of Karnataka High Court. May not be. May not be. It will take winding up.
If they are not prejudiced, directly prejudiced, then why should they?
They are not.
Yes.
Therefore, he has given up only now.
Okay.
He has given up. Yeah. Next.
Weekly list item 1. Writ appeal 2530 of 2024.
Then next.
2.30. You are not here. It's not a matter.
Yes, my lord.
Then you are stating.
I'm sorry.
Not ready.
The other day it was called and I was given an impression that it is adjourned 1 week.
You want 1 week? Really want time?
No, my lord, I don't have the records.
Okay. The weekly list will be prepared. No? Yes, very good. Next.
Item 2, writ appeal 3037 of 2024.
Same one.
Item 3, writ appeal 3141 of 2024.
Yes, next.
Item has been disposed of. Item 5.
Yes, Mr. Panda. I not here, state. You're not here. 2 affairs.
But I can take notice, sir.
No, you only are appellant.
Oh, appellant.
Last print Mr. Mandi was there.
Print next week. Next.
Item 6, writ appeal 514 of 2025.
This is also there.
This also, no?
They sought for time, history. Yes.
Item 7 and 8 have been adjourned. Item 9. Please appeal 149 to 2025.
Same order.
Item 13. Read appeal 151 of 2024.
Item 11 was there.
Item 11.
Time for next.
They have taken time, Mr. Mishra. They have taken time. Yes.
Item 13.
Item 13. I am respondent number 8. This rate of appeal was at least called thrice matter. In all the occasions, the counsel for the
Is absent.
yes, ma'am.
Do you have counsel's phone number? We have a counsel's number, phone number.
Day before yesterday, it was called. And it was about to reach yesterday.
Just call advocate and tell that opposite side advocate is arguing the matter. Come to court running. Wait, he will come. Yeah. Pass over.
Item 14. Read appeal 444 of 2024.
Item 14 can be passed over, Manu.
Pass over.
Pass.
Yes.
Item 15. Read appeal 788 of 2024.
15.
15. The accountant general here. The petitioner not available.
Not here. In history.
My presence won't.
History.
My presence may record.
Presence of panel counsel for the AGF. The AGF is not in. Okay.
Item 6. Read appeal 2080 of 2024.
May it please. My lord, the petitioner's claim before the Honorable Single Judge was to pay her remuneration as education volunteer for the period from 36/2006 to 31/3/2008. The period she has worked as education volunteer under the EGS and AI scheme. Education volunteer under a particular scheme, that is EGS and AI scheme. And the second prayer before the Honorable Judge was, since EGS scheme was abolished, she should be observed as Ganashikshak in terms of the government order of 2008, 16/2/2008.
GO dated
16/2/2008 under Annexure 7. Because all erstwhile education volunteers
have been observed. They were senior to you or junior to you?
They are junior to me. But when I filed the first writ petition was, several rounds of litigations were filed. The first writ petition was filed way back in the year 2009. That is 6785 of 2009. That was disposed of on 5/5/2009 with a direction to the collector to consider my case for release of para 9 of the impugned order.
Yeah.
That
you are not worked it.
No. Yes. That is the findings of the Honorable Single Judge. My lord, but I will show only 2 documents to your lordships. Those documents unequivocally shows that I have worked for that period. My lord, may kindly come to my lord, Annexure 3 at page 26. Page 26. Because the dispute is relating to the period from 36/2006 to 31/3/2008. Whether I have worked for that period or not. The collector says I have not worked for that period. My lord, may kindly come to Annexure 3 at page 26. Their own document. This document, this order was issued by the district project coordinator, DPEP Sarva Shiksha to all the headmasters of primary and upper primary school, Jharpani. My school is Jharpani, Tumudi Banda.
This is addressed to whom?
But this is addressed to the headmaster. Headmaster of that.
Who are, but how you figure here?
Well, because they say that education, that center has already been closed since 2005. That is their own ground.
No,
that is their own stand.
To show that you have worked. Where is the evidence?
Yes. Well, your CPA kindly see Annexure 3. Because
Annexure 3 does not have your name at all.
Well, Annexure 3, my lord, I was the education volunteer in that EGS center. In one education volunteer is there. So I was also discharging the duties of headmistress of that education, that EGS center. So therefore, by virtue of
how to assume that?
Well, by virtue of this order, my lord, an amount of rupees 1,027 was remitted for girls' uniform. You also may kindly see the tenor of that letter. Subject release of fund for girls in uniform.
That it was functional, but how can we assume that even
they say, well, the entire impugned order is that the center has already been closed since 1/10/2005.
Yeah.
But may I see that order of the collector. Well, 3 orders have been.
Learned Single refers to.
Well, Learned Single has believed the report of the inquiry report of the collector and say that
the village Panchayat chairman.
Well, on the contrary, I have filed some affidavits of the Sarpanch and other bodies. They say that I was functioning as education volunteer in that center. But those documents were not taken into consideration.
What is of the education volunteer?
Education volunteer to teach students.
Whether they will take attendance of...
Yes, I have given that. I have given that. Your Lordship, kindly see.
Where is the attendance?
Yes, my Lord, kindly see. Annexure 3, my Lord, has already seen. Then the...
Annexure 3 will not help you.
Yes, it's fine. Then, my Lord, a savings passbook. That copy I have given at page 27.
What it shows?
Well, it shows that some amount was deposited in the name of the TGS center.
Who deposited the amount?
Well,
what amount has been deposited?
The petitioner has deposited.
With the?
Well, in the
which bank account?
Bank account, because there is a bank account in the name of the EGS center. And both president and headmaster.
How many remittances are made?
Well, remittance page 28, your Lordship, kindly see.
28.
Yes. That whatever money was given, that is for uniform and other things. That is there.
Amounts are different.
200 rupees, 100.
Yes.
Anybody can deposit that money.
But all these documents I have filed.
For what period it is?
That is for the period from, that is 2000.
It is April 2019.
From 36/2006 to 31. You should approve.
Yes. Your Lordship, may kindly come to page 29.
29.
Page 29. This is the monitoring tool for quality dimensions.
For which period? What period?
Well, this is of 2007. 2007, during the disputed period.
But it is submitted when?
Who submitted this?
Well, I have submitted. Signature of the headmaster with date. Signature of headmaster with date.
Submitted to whom?
But there is a format that is monitoring tool for quality dimensions, elementary level reporting performance to CRCC quarterly. But this shows that I was working for that period.
To whom you submitted this document?
But this was submitted to the CRCC.
Where is that?
But your Lordship, my reporting performance CC quarterly. At the top.
No, it is simply the year is mentioned.
Yes.
And the date.
Nothing.
But 2000, for the year 2007, that is there. Then your Lordship, may kindly see, this is most important document, page 30.
What is name of the client?
My Jyotirmay Sadangi. And she signed at the bottom, your Lordship, may kindly see Jyotirmay. Then
self-generated document.
Yes. Then your Lordship, may kindly
records are there. Then cannot go by your own generation of document.
But I'm conscious of that. Your Lordship may kindly come to page 30. Page 30. This is the attendance of students.
How many students were there in your class?
My Lord,
In your class, how many students?
Your Lordship may kindly come to page 30 and 31.
Yeah.
Serial number 6. Barguda. It is in vernacular. Barguda. Well, students that has been mentioned in different classes, that is there.
But if you see the format,
32 and 30.
no, the format is 29.
Yes.
Which you have filled up in year to
No, this is
it shows that you are only persons.
no.
Persons are there.
This was submitted on 1/5/2007. This is relating to different centers also. And so far as my center is concerned, my center figures at serial number 6. That is in vernacular. And no, my lord, in different classes. How many ST, how many SC, and total like this.
How many students totally?
Students, my lord, I have to calculate. That is.
This is 1/5/2007.
Class 1 to 5.
1 second. When the academic year begins, when it ends?
Well, the academic year.
When it begins, when it ends?
From April to June. Yes. A dispute is relating to the period from 2006 to 2008. Because I have worked for that period.
April to June.
How can I? April to June?
No. Well, it begins in May.
May, which date it begins?
Well, yeah.
After the summer vacation.
After the summer vacation holidays.
How much? What is that date?
31st. May I go to 30th? 31st.
If it is May 31st, kindly come to page 31. See the rock bottom, it is 1st May 2000.
Yes.
How can that? In 1st May, there will be no school at all. Yes, it's your document.
Year is 2007-2008.
You have put the date.
Yes.
Kindly see the date.
Well, he has signed on 1/5/2007. Then your Lordship may kindly come.
Attendance register is maintained in all classrooms. The class teacher will make the entry.
Yes.
Subsequently, that is forwarded to the head of the institution, principal. He will put the signature on daily basis under your rules.
Well, and your Lordship is absolutely correct. So far as EGS centers are concerned, that is meant for primary school students. So there is only one education volunteer who uses to teach the students.
But there is no session at all. During May, on 1/5, where is the classroom?
Well, here your Lordship may kindly see, so far as this session, so far as EGS centers are concerned, that session is not being followed in respect of EGS centers.
Where have you stated such a statement? You are only arguing.
And your Lordship may kindly turn to page 32.
The doctor document does not have the same date at all. And she has.
But if your Lordship will require, I will produce the original. I will produce the original for your Lordship perusal.
If it is original.
Yes.
Rated by whom?
Whether the points
rated by the petitioner.
Yes.
How can then?
He is the only teacher and he is the only education
cannot bring for your Lordship, which he has not agitated before the reading.
No, these all these documents were filed before the Honorable Singh.
Then petition is not annexed.
Your Lordship, may kindly see my predicament. Twice I have approached this Honorable Court.
What for? Now collector says no. The chairman of the Gram Panchayat says no. There is no material even otherwise to watch that you worked there. You are producing attendance register for the 1st May 2007 when the classes are not held.
Well, that is the findings of the collector.
No. Even according to you, nobody of its.
No. But your Lordship, kindly
see. The academic year, when the academic year begins, under your rules,
Which are those rules?
That is 31st May.
31st May.
31st
No, on Fund 7, how we
So far as my submission before your lordship is, yes, letters are concerned, these are non-formal schools, not formal schools.
whether non-formal schools run even during May?
Yes, yes.
That somebody
Yes,
should
yes.
say that. Huh?
Yes, yes. Yes, yes. So far as non-formal schools are concerned, non-formal schools, my lord, general rules will not be applicable because their duty.
That's right.
But
We want to know whether during the month of May, that is peak of the summer in Orissa, whether schools are run or not is the question.
it is center. But this is not a formal school.
there is a general circular
No, no, no,
government
no,
to close down the schools during.
No, but so far as yes, sir,
One who violates, he will be penalized.
No, that is not correct.
That is the circular of the government.
That every table for general schools. So far as non-formal schools are concerned.
No, whether formal or non-formal.
Yes.
Summer applies equally to the Raja and Rank.
Yes.
How can there be discrimination?
There can be no deviation to that.
And your lordship may kindly turn to another
Unless you
slide.
go to schools in which is that oldest area in your place. Some place, Uti or Orissa.
Both are extreme climates.
Malkangiri. Unless you hold schools in Malkangiri.
That is the coldest.
At least you produce some material.
Yes, I will produce some materials. And another aspect of this case is, my lord, it is a post-decisional hearing. Your lordship very well knows about the judgment of the Honorable Appeals Court. So far as post-decisional hearings are concerned, that yields no fruitful result. Thrice it, my lord, thrice
Maneka Gandhi, Apex Court first time adopted post-decisional hearing. All right, you have taken a decision. Now hear them and thereafter take a further.
my lord, here thrice it has been done. The
Where is the material? Now there is a
my
final.
lord, in each and every time, in each and every order, the collector has said that the center has been.
Not only collector. Gram Panchayat chairman has said.
Well, Gram Panchayat chairman has one affidavit. Your lordship may kindly see that affidavit is there.
Kindly come to para 20 of the findings.
Yes, yes, my lord, I have seen. Well, I have gone through that. Your lordship may kindly see the affidavit which the Sarpanch has given me. That affidavit I have put before the Honorable Single Judge, but Honorable Single Judge has held. These affidavits are self-serving in nature.
Yes, we feel like that now. Unless, Mr. Singh, you produce some independent.
Yes, yes, sir. I will produce.
Allow me to accept the request. Yes.
17, you can read about 34.
Next week.
Item 18, read of it 40 of 2025. Item 19, read of it 79 of 2025.
Yeah, it means.
Hello. The petitioner was appointed as a constable on 1 to 85
State. Are you ready in the matter?
Item 20. It is covered by a coordinate judgment of this honorable. Yes.
What is the point?
The point is that after he was convicted by the trial court, thereafter he was acquitted by the Hon'Ble High Court. After being acquitted, he was reinstated, but so far as the area was concerned, it was extraordinarily without pay. That order was challenged before the Honorable Single Judge, and the Honorable Single Judge.
What is fault with the management?
Case was initiated. The criminal case was initiated by the department, it's a Vigilance Department. And that has been specifically the judgment which I am relying on. There also exactly the similar thing happened. The disciplinary proceeding was dropped. Also, not only that, he was convicted in the trial court and appellate court acquitted him. Thereafter, he had claimed that salary, and the Honorable Single has also dismissed. The Honorable Division Bench has categorically, relying on all the judgments of the Honorable Supreme Court, said that since it is not the fault of the accused to be out of service, the very clear. All the judgments have been exactly, facts are also akin. Same vigilance case and all that. I'm also giving copy of the judgment to my learned friend.
But in the case of honorable acquittal.
Oh, yes.
Honorable acquittal. Very acquittal.
Para 5 and para 5 of
I'm just saying, I'm just saying that.
Para 5 and para 5.1 of the impugned order at page 11.
No, I'm just saying the acquittal order of this.
Just the observation of the single judge.
Yes. The page 14. But can you para 720, page 20 of the judgment of this Hon'Ble Court will file acquitting the person, according to the appellant. May page para 7, page 20.
For that criminal case?
That was under section 7, taking allegation of taking bribe. Section 7, therefore, the Lordship categorically said that the page 21 demand of illegal ratification is signed on to constitute the offence, relying on the judgment of B. Jairaj versus State of Andhra Pradesh. And gratification and absence of any proof of demand for illegal gratification, the use of corrupt and illegal means for abuse of power by a public servant cannot said to have been established. In that case, as stated earlier, there is no whisper as to from whom or which of the was by OMBD officials or the money was received by any illegal manner. That apart, as per the prosecution case, both the appellants were found sitting inside the taker and not in active participation in the act of vehicle. It must be the vigilance and the concerned the government. It must be the staff of the. I'm just
if third party has lost, then you are not entitled.
The third party might have
itself has lost. You are entitled.
Yes, my lord. Yes, my lord. That can say there. Maybe I will check it and coming next week.
Where is that order? The conviction, acquittal order.
Acquittal order is at page 16, 16.
Go to 16. There only will get one.
There only will. I'm just saying. Para 2, they have stated about his lordship was stated about the fact. Also, checking that is someone could respond to continuing but it's by the vigilance staff only. It is by the vigilance staff only.
Vigilance staff means the complaint.
Not said that there
some
information
by somebody, na?
It is the vigilance. As it appears from para 2, my lord, for the purpose of disposal of the the vigilance authority.
Which department?
OMBD, my lord, some motor vehicle OMBD, that transport department. OMBD in this. deputation, they were in the transport department.
Which department?
Police department, constable, and deputation to transport department. Because as your lordship will file from para 2, the vigilance authorities received an information that OMBD staff under the regional transport officer by discharging the official vehicle, checking the include railway bridge and were quality illegal application, cash from different vehicles. Pursuant to the order of the SP Vigilance, vigilance officers and other staff proceeded for survey check. They found some officials taking the vehicles and some of the staff sitting inside the taker. It was either someone from inside the taker seeing the vehicle staff threw out a matchbox which fell near the front wheel of the taker and found to be containing in some case. On such, vigilance officials alleged found some bags inside taker containing so and so. So it is vigilance staff, the prosecution it has been edited. And their lordship will see the judgment by relying on the Supreme Court that judgment, copy of the judgment also, that if it is the third party money, in the case of other offences, if not by department itself, then they have got they can be convicted. Based on that, the Hon'Ble division of this Hon'Ble para 6.9. The
Where is the acquittal order?
Acquittal that order it's 21 level also can see.
21.
Yes. 20 it starts from page 20 para 7. Even question is at page 21.
From the beginning, facts are stated in which paragraph?
Para 16. Sorry, page 16.
Page 16.
Page 16 para 2. I was just placing that. Para 17. Para 16 is the
Para page.
Page 17. Page 17 para. Sorry.
Para 2. Vigilance authorities information.
Yes.
Who is the informant?
That is not there.
Received the information means vigilance authorities are not the informants.
No, that is not there. They didn't find. They'll have to find the trial court judgment. Trial court judgment only we can find it out. Otherwise, from the criminal case record only can find it out.
Do you have trial court judgment? It must be private person only from whom money is received or demanded. That person will give information.
So it is. As it happens, it is not a case of that. General information they have received. As it happens on para 2, general information they received to staff are demanding bribe and taking bribe and all that. That is the general information. People also you can get it from the. You'll also get it. I'll ask my friend to get the criminal record there. Criminal case record.
To enable the advocacy. From petitioner to assert and tell as to who has informed the vigilance authorities about thievery and illegal gratification in OMBD.
So I can get it from the FIR itself, it will be sufficient.
That's what.
Yes, ma'am.
We will know.
What's the blessing? We come up to tools.
Yes. Special notice.
For 6:15
Passover.
Six item 15.
Item 6.
Item 6 and item 15.
You want? So,
Wait, weekly list or daily list?
Let it sit there.
also 15.
This is. Item 6 and 6.
The 15 has been adjourned to nation.
It will be there in the next week.
Next week it will come.
Yes.
Absolutely.
No, we'll take it next week.
Recruitment 2025 recruitment.
What's the urgency? Serial number 6.
Six, ma'am.
Secretary of the OPSC. Where is your friend? For his absence, go and bring. Yes. Go and bring your friend. Because he is the our friend, na?
He's not absent 2 p.m.
After 2 p.m. All right. Just pass.
Special notice WPC 10784 of 2026.
That bank matter. He said the entire money is paid. We have the file. We told him. Where is that? They call it. Sorry. Entire money. Yes. After the counsel for the petitions. If client has remitted the entire loan amount to bank during the auction process, and therefore it draws our attention to the application in IN supported by an affidavit seeking the first. We notice from governments of the petition that the collateral security happens to be the residential house, the petitioner, and that the auction was held on 26/3/2026 pursuant to the advertisement dated 11/3/2026. Yes, he has already deposited the sum of rupees 27,45,000 on 30 March 2026. That is, and with after the auction was an arguable case in the middle for the interdicting issuance of this and also confirmation of the auction. Next, in the most circumstances, IN number so and so it is pulled up, directing the OP bank not to issue sale certificate and further not to confirm the auction sale in the next date of first call this matter immediately after service. Okay.
matter. These are matters which your lordship directed to be listed on 20th March. Because
whenever I sit there.
For my lord, content matter arising out of it will being listed tomorrow.
Perhaps already listings already prepared. Next,
not yet. The problem is the content matter arising out of sales models is being listed tomorrow. So unless this review application is listed,
you can mention tomorrow. Just we have filed review petition like that. We can consider.
Oblige.
So we'll be disturbing your my lord.
Yes.
13th is declared holiday.
Declared holiday.
Today got the notification.
Already
got it.
We would have waited till 13th, but tomorrow.
We have got it. It is not declared. It is declared at your instance.
That always happens.
That is the full statement.
Yes.
That matter, both of us were arguing related to the DRAT matter. That residential house under auction that was I'm doing. The lordships in course of arguments, the lordships have suggested a borrower has agreed to deposit certain money, and there is small modification is necessary in that because of the statement of the bank. The lordships have directed certain amount. Some difference. 13th will be the last date to make the first installment deposit. So if it can come tomorrow, my friend has filed a review petition. I have also.
Well, brother is not there. Brother is going somewhere else.
Because the first date will be on 13th. 3 weeks falls on 13th.
Even if
that will also keep on done for 16th.
That's what. On 16th.
Well, that passport matter, item 13. I can telephone to that council. He request to my learned friend as he is not present today. So may I request my lord, let the matter be listed on 20th in supplement.
20. All right. Next.
Supplementary list.
Lordship online.
Yes. Yes.
20th
we have put it. 21st we have put it. 20th, not 21st.
Who is matter?
We were Mr. Venkatraman is.
Yes, ma'am.
Yes. Today. Yes. Oh, yes.
Only 5 minutes.
Item
Yes.
Only 5 minutes.
Lordship, before my learned friend starts, may I make a request? Lord,
Yes.
Lordship, today by some mistake, my juniors have not brought. Can you kept on 23rd? I'll come physically and appear before my lord.
But why should you? It's heard and it's a very short point. And
No,
just
but that day my lordships had given us some food for thought. I'm doing some research on the legal principles. So you Mr. Venkatraman can make his arguments today. Further, it can be argued on 23rd, lordship.
Well, he has raised 2 points. According to Malad, I'm instructed he has raised 2 points. I have answers in the rule itself for the 2 points. He has raised 2 important points. What my friend has canvassed this, my lord. Please see the explanation. This is his first of argument. Rule 8. Rule 8 explanation. 1A. For the purpose of this rule, departmental proceedings shall be deemed to be instituted on the date on which statement of charges is issued to the government servant or pensioner, or if the government servant has been placed under suspension from an earlier date on such date. So my friend's contention is the expression pensioner does not appear in the second limb. And therefore, this is bad. His case has to be, Lord, why should we do that? Why should we? Please see, Lord, it's so ideal. The rule has started it beautifully. The reason is simple. Please come back to the rule. A departmental proceeding shall be deemed to be instituted on the date on which statement of charges is issued to the government servant or pensioner. I don't come under that limb. Second limb starts, or if the government servant has been placed under suspension from an earlier date on such date. Please note the date, my lord. The date of suspension is, which is undisputed, is 22/11/2019.
That is subsequent order of the CAT.
Yes. No, 22, no. Suspension is 22/11/2000. Correct. Disciplinary proceedings commenced on 22/11/2019. On which day he was a serving government servant, not a pensioner. My friend cannot get the benefit. An absence of an expression pensioner, saying that you have done it to a pensioner who is not covered under the second class, may be a meaningful submission for a different case. What we have done in this case is on 22.
Sir, small question. As on the date the CAT decided the matter, you had not served the charge memo at all.
I'm not on charge memo. That's the first limb. There are two limbs. Please tell me.
Yes, 1A.
Yes. There are two limbs to 1A, two parts to 1A. Departmental proceedings shall be deemed to be instituted on the date on which statement of charges is issued to the government servant or pensioner. That's one date. Or they're independent, not and. Or correct. If the government servant has been placed under suspension from an earlier date on such date. So charge memo comes later. So if charge memo is issued directly, then charge memo date will be the relevant date. If he is suspended anterior to issuance of a charge memo, then the earlier of the two, which is the suspension date, will provide. In this case, the suspension date is 2019, on which date he is a serving government servant and not a pensioner. So absence of the expression pensioner in the second limb cannot work in my friend's favor. It may work for a different case. Suppose somebody retires and is drawing pension. Then we seek to suspend. Not possible at all. I don't know how. Assuming somebody attempts it. In second limb, he can say, you can't, suspension can happen only when somebody is in service. So the expression pensioner is superfluous, redundant, odious, and unworkable. That's why the rule maker has not put that word pensioner in the second bucket. So there are two buckets. Charge sheet, then charge sheet date. If suspension is anterior to charge sheet, then the suspension date. And suspension will always be only to a serving government employee. He is a serving government employee. Now, this is one question which can be legally answered. Now, the second submission my friend makes is, Lord, please come to Rule 8.2c. This is the second ground. Same rule, Rule 8, subclause 2, subclause C. Subclause 2. Subclause C. This 4-year was arguing on the 4-year issue. Fortunately, we all have benefited now by hearing this video whenever we want the hearing. So we're able to see what our pusher has actually argued. So I'm obliged and also to the briefing instructing counsels and my colleagues in the department offices. Please come to 2B. The departmental proceedings, if not instituted while the government was in service, correct, whether before his retirement or during his re-employment, this clause will apply only to a pensioner. First of all, threshold. So please, the departmental proceeding, 2C, subclause 2C, 8.2C. May I read it, bro?
Internet is fine. Last.
Rule 8, subclause 2, subclause 3, C. 8.2. Yes, yeah, my lord is right. 8.2C.
2 small c.
Yes. My lord is absolutely right. Dot on the point. Dot on the point. The departmental proceedings, my lord has it? Instituted.
Yes. If not instituted.
If not instituted, while government servant was in service, whether before his retirement or during his re-employment, subclause 1, shall not be instituted save with the sanction of the president in format. So, 2, shall not be in respect of any event which took place more than 4 years before such institution.
Limit.
And, yes, and 3, shall be concluded, conducted by such authority in such place as the president may direct and in accordance with the procedure. Yes, so all the three are not relevant. This 4-year limitation will apply to a pensioner. Not a pensioner cannot be kept in tenterhooks for law. Yes. But my friend is putting a case. You have been investigating disproportionate for 10 years from 2001 to 2014. You instituted 4 years later in 2000. We can do all that as long as he's a government servant. We can't read 4-year limitation, but we can rewrite the rule. This very threshold 4-year limitation under 2C apply only to a pensioner. The caveat is very clear. It very clearly says the departmental proceedings, if not instituted while the government servant was, we have instituted it on 22/11/2019. Please see, my lord, two things. See two orders. 22/11/2019 order, how it is worded. That is, my lord, page 23. 23. It's very clear. It's a presidential order. 22/11/2019, where disciplinary proceedings are being contemplated against so and so. Now, therefore, the president, in exercise of the powers conferred under Rule 10(1) of the Civil so and so, hereby places so and so under suspension with immediate effect. It is further ordered, headquarters of so and so shall be the office of Chief Commissioner, Bhubaneswar Zone, and he shall not leave the headquarters without obtaining the prior permission of the competent authority. He will be entitled to subsistence allowance. Now come to the charge sheet. Now the charge sheet for the department proceedings very clearly traces it to the first order, which is found at page 68, Annexure 6.
Mr. ASG.
Yes.
Mr. Venkatraman. The issue is whether an employee can retire, whether suspension can overstay retirement of employee. That question may not be relevant. If that question is raised, the answer has to be in the negative. Because there is some elementary support from Justice Ramajoy's book, which I read yesterday again. There is some indication. Suspension is treated by Justice Ramajoy in a separate chapter under 7 subheadings. Like one subheading lends some support to this view. Because of the very idea of suspension, the idea of suspension, Mr. Ramajoy says, quoting to 72 Supreme Court judgment, keep employee away from regular work. That is the seed idea of suspension. It may be X, Y, Z reasons. We are not on that. Question is whether suspension can continue after the retirement of the employee. That question itself will not arise. The question raises is, if an employee is kept under suspension and subsequently he is superannuated, whether he is entitled to all the terminal benefits or not. That should be the question. That was, in fact, a challenged suspension order. What was challenged by the tribunal was the suspension order. And filed his written statement or written arguments also in that line of pleadings, prayer.
Therefore, adverse my lord has hit it. It can't be much. It can't be better at all. Adverse civil consequences has commenced for this gentleman on 22/11/2019. Therefore, we now can't change the goalpost dates, suiting our own convenience. And Lord, explanation is absolutely dot on the point. This is by saying that departmental proceedings shall be deemed, it's a deeming fiction, to be instituted on the date on which statement of charge is issued to the government servant or pensioner, or,
before that comma, then or,
and then two words are very important. If the government servant has been
Mr. ESG, or is a distinction.
Yes.
It means I there is a comma.
My lord, and there are two things it says.
Second part, Mr. ASG, second part is an independent provision.
Yes, yes.
So that
for two reasons. I'll add two reasons for that. The reason I'll add two reasons. Who is independent? A, or if the government servant has been placed under suspension from an earlier day, comma, on such day. It seals it. So on 22/11/2019, if you suspend him, now to say we can't defeat this explanation by saying, no, you have continued suspension. On retirement, everything gets washed up under the gutter. Absolutely. Then why are we writing this rule? Why are we making this explanation? And what? Incidentally, 8.2a, it's a proceeding by itself. Please come to 8.2a. The department proceedings under sub 1, if instituted the government servant was in service, whether before his retirement or due temporal, shall, after the final retirement of the government servant, be deeply proceeding under this rule and shall be continued and concluded by the authority by which they were commenced. So we can't be mutilating all rule to suit one gentleman for him to escape the process of law. This is completely rewriting the whole rule 8, my lord, contrary to the intention. The law should not permit it. Is our very humble submission. These are the two submissions my friend has made, but I have closed my rejoinder. I don't know what is going to be argued again on 23rd, my lord. Your lordship,
to this I can respond now. Lordship, what I understand from the rules, the second part does not contain the word pensioner because the suspension is over when he retires. Admitted fact that he was given order of charge sheet after his retirement. His retirement order is on record. I don't have the page. I think it should be Annexure A3 because I don't have the order of superannuation has been issued that he superannuated on 31st of January 2022. So the foundational fact is that
he retired on
31st of January 2022. Therefore, the foundation fact is that on the date the charge sheet was, and when he retires, he is a pensioner. He becomes a pensioner because officially, no, because the rule says their rule only. The rule says if there's some dispute proceeding pending, he'll get provisional pension.
That is different. But
then a pensioner gets either a pension or a provisional pension. So he's not a pensioner. That is some argument which is very far-fetched. I don't understand how it can be made in a person retires, he becomes a pensioner.
And therefore, my lord, if you suspect, so how do you are virtually?
Yes, I'm explaining why in the second column the word pension is not given for the very specific reason that suspension gets over on the date of retirement, and therefore the charge sheet cannot relate back to an elder date. That is why specifically this rule is silent about pensioner, and only in a government servant if he is suspended and it relates back to the date of suspension. Number one. But
one minute, sir, so that we finish this point. One line rejoin there. Not we are actually, instead of constructing a provision, we are destructing the provision. What is the, if somebody is the government who does not know that somebody will retire in the course of the inquiry and suspension, please see. Or if the government servant has been placed under suspension from an earlier date on such date, and my friend reads, and if so, he retires, the suspension will abate. He is adding one sentence. Well, what does it say? For the purpose of these rules, commencement. This whole rule is for commencement, not for conclusion. I can understand conclusion or charge sheet is what is called. What does it say? For the purpose of this rule, departmental. We can't lose sight of the words. Departmental proceeding shall be deemed to be instituted. Deemed to be instituted. Has it been instituted? No, this is a completely destructive interpretation of law. The lordship should not entertain it. Is of some submission.
It is for, I'll explain again. In the first part, when a charge sheet is given, I am covered in the first part. I am a pensioner. I get a charge sheet on 1st of November 2024, and therefore my date of receiving the disciplinary proceeding is 1st of November 2024.
It's wrong. If we have not done the second link, my friend is right.
No. In the
One
second,
minute. But where does it say? Once charge sheet, but what is he saying? Once charge sheet is issued, second limb of the provision will get subsumed into the, where does it say?
No, I'm not saying. I'm only explaining
my knowledge of
Mr. Venkatraman, let me.
the rule as it is will be interpreted. We can be introducing our own notions of the rule by saying that this is how the rule should be. He is actually rewriting President's rule under Article 309. That's all I can say. But we'll give a written note on both. Your Lordship may finally resolve it. Whatever my friend wants to say, let him put it in writing. We'll also put it in writing. Your Lordship may then take a call. Not difficult. Not difficult. This explanation is only for. I'm sorry, Bala. I'm sorry.
One query, sir.
Yes, Bala.
Whether the receipt has been issued in this case to the government servant or to the pensioner?
It was issued to the pensioner, no doubt. That's not when I say pensioner, he's a provisional pensioner. He's a provisional pensioner. Now, the point is, now I can, when does the proceeding get initiated? There are two limbs to initiation. May I answer your Lordship's question? But suppose, I'll answer it. We'll test it this case itself. Suppose we have not suspended this gentleman on 22/11/2009. Let us put a scenario. On 22/11/2019, we don't suspend him. That is the suspension date which we have now issued. 22/11/2019, page 23. We don't suspend him. Then he retires on 22nd January, 31st January 2022. We don't do anything. Because we can't suspend him after that. He has retired. Then I issue the charge memo on 1/11/2024. Then I will come under clause 1. Absolutely right. Clause 1 will come. My friend can canvass till the house return. I don't have a problem. Our case is exactly the opposite. What we have done is, please come to the second limb. What does it say? Department proceedings shall be deemed to be instituted on what? On the date on which statement of charge is issued. Or if the government servant has been placed under suspension from an earlier date. Therefore, we have done that activity here. The act of suspension has happened on 22/11/2019. What does this provision say? This provision is not for completion. This provision is for initiation. It very clearly says department proceedings shall be deemed to be instituted. So for institution, if I have not suspended him, given he a charge memo in 2024, clause 1. If I have suspended him, then anterior in time, that will operate. When was it initiated? It was initiated on 22/11/2019. And rightly so, my friend's client has gone up to CAT, fighting on that suspension. He did not wait for a charge sheet. He is fighting his suspension. And that suspension is now revoked. When the law, where does the law permit that revocation? Is the question. And his reliance on 82C, which we read it, please come to 82C. It doesn't permit. 82C is only when, again the word is instituted. Please see 82C one more time. The expression used in 82C is departmental proceedings, if not instituted. He reads institution as conclusion, as final mandate. How is it possible? Well, we'll give a written notes for that. Both of us will give a written notes.
No, Your Lordship, I need a little bit of time because today I don't have the file. Secondly, I'm doing some research. Your Lordship, that unius exclusio, Your Lordship suggested, I'm doing some research on that. So I request that it may be kept on 23rd. I'll come on that day, keep it at 2 o'clock. I'll personally be present with my written notes of arguments if necessary. Lordship, but one fact is that we are, Your Lordship, one thing else which my learned friend did not answer. The fact remains that we are here on judicial scrutiny of the CAT order. In the CAT order was before the charge sheet was given. The question of whether the charge sheet was there or not, CAT could not have done it before. The CAT could not have dreamt. The CAT could not have dreamt about that. Therefore, the question whether the charge sheet is there or not there is not at all a factor which can be considered.
Why? How can we consider? You challenge the suspension which is anterior in time.
Yes. That's what
Impute
it- yes.
anterior in time is what the law. And 2C says, 8.2C says, department proceedings, if not instituted, like we can keep fighting. Let him say, put a written note.
No, we are not fighting. What I'm saying, what my submission was a very simple submission that the CAT had no knowledge of this and therefore CAT could not have even decided on that.
Did not. It is not a futile plea. It's an absolutely a futile plea. Why did he challenge the suspension? Because he's agreed. Did he
Yes.
put a charge sheet? Why did he challenge it?
And
So
that-
what is my friend saying? Suspension, I can challenge suspension. All right, that is all right. I can retire, that is my right. All will wash off under the gutter, that is my right. Where does all this come from law? We have to edify our contentions based on law. We can say his view, and both of us have a different view. Your lordship may resolve it. We'll put it in writing. Please resolve it. To say, my lord, see how destructive this law is. To say a person can be suspended, a person can, proceedings can carry on, investigation carry on his retirement, everything will abate. How can that be a law? Where is the position in rule? Where does which rule says it will abate? Well, abatement because it's a right, but it's an extinguishment of a serious charge. It's an abatement of a serious offense. Unless abatement is conceived in law, how can court conceive it? Through an interpretation or a litigant's arguments is the case. Let him argue on 23rd, we'll put our written notes. We are not.
Mr. SG, three things arise. Your submission, Mr. Mohanty, your submission yesterday. Again, I went and for midnight I long back. I looked into Groom's legal magazines. I looked into statute. That maxim which you quoted, expressio unius exclusio ulterius. That is treated as a very weak maxim in England, in America and Australia. Justice Kirby's judgment, Michael Kirby's judgment is there. He is very high by Apex Court. Many times Apex Court has referred to his judgment, Australian High Court judgment, Judge Mr. So that may not be applicable to this rule at all. This is number one. Number two, I were only discussing now.
Yes.
I am speaking aloud, that's all.
Yes.
In favor, etc. Because for the first time, this question is being argued on the floor of the court.
Yes.
And both of you say that there are no judgments of any of the high courts in the country. So we have to be a little slow and steady also, which we are. And the second part, deeming clause, we also agree with the DSG that there cannot be abatement of legal proceedings except when the law says,
yes,
for example, abatement of criminal proceedings under Criminal Procedure Code on the death of the accused. Because law provides for that, there is abatement. This is how we have seen that the idea. No question of abatement. On the other hand, the provision appears to be anti-abatement. There is no question of abatement because the rule does not provide for abatement of the proceedings, saying that once the employee retires, that will put an end to all the proceedings pending against him. That's not the law.
No, I agree with that.
It should continue. This is second aspect of the matter. Whether, again we are repeating, whether suspension can continue after the determination of the service, be it by contract, because contract has come to an end, because status has come to an end, because he has attained age of superannuation, there is determination of contract of service, status of service. Beyond that, whether the suspension would continue, we are very much doubtful. And doubt arises because of the version of the opinio juris, that is opinion of great expert in the service law. The question is not whether suspension continues. That is not the question. If that were to be the question, answer will be no.
unless the law itself says suspension is deemed to continue, which law may say because of the deeming provision, if there is one. We don't see such a problem.
No, 82 says once initiated, if proceedings initiated prior to retirement will continue post-retirement. Same rule, yes. Same rule says.
But it does say, Mr. ASG, with due respect, we differ from your view. It only speaks of continuation of the departmental proceeding. It does not utter one word about the continuation of suspension status.
But I have it's a tiebreaker. It's a tiebreaker to say we can continue. Yet he will not be suspended. He is relieved. How can we continue? But it's putting out.
No, we are not saying that. We are only taking our interpretation on either A rule A2. C, that's all. A2C does not utter a single word about suspension. It only is an enabling provision which says the employer can continue the disciplinary proceeding even after retirement, subject to XYZ factors. It does not say that once an employee is suspended during the tenure of his employment, that suspension would continue even after demitting of his office. It does not say.
Can I aid your lordship in 1 minute answer and leave it? If contract is broken according to one perception or one noble view, contract is broken, then why should the rule say you will continue? So you will continue proceeding, but contract is broken. Then that is void. Somebody will go and impugn it and say, according to this court's view, contract is broken, employee release is broken. So how can you continue? So the reverse should not happen. That is the worry you are having.
I will answer your question. No, sir. In Tulsi Ram Patel versus Union of India, a government service, though begins with a contract, it graduates to the level of status, therefore contract is lost. There is an answer to your question. The question in service jurisprudence. With due respect.
We'll work on it. What we will do, I have only one doubt. Let us analyze it in every way. Final conclusion, your lordship will have to conclude. His suspension goes, which means everything should go. That is the consequence. Suspension continues. Suspension goes, department inquiry can continue. Then what is the leak matter?
That's all. Notwithstanding rescinding of the suspension, or because the suspension comes to an end in view of the collapse of the substratum, such as retirement, removal, dismissal, or the death of an employee. These are the factors which the jurisprudence, service jurisprudence takes care of.
Very good. We have just found out. I'll come back. I'll work on it and come back. Constitutional.
Cessation of suspension does not mean abatement of the departmental proceedings.
Correct.
In other words, suspension is not a sine qua non for initiation, continuation, or determination of the proceedings.
Lordship. Very right way, Lordship. Highly obliged.
Any standard book, Rama guys.
Yes. Lordship.
All they say like this. So they are, though in so many, the version may be, textual version may be different, but this is what we can churn out from what the Krishna wants, even VD Kulas Krishna. They have.
We'll work on it. We'll bring the constitutional bench judgments, everything will put compilation. We'll put a neat written notes. What happened? What is the legal citra? We'll put it. Because, my lord, it will work both ways. We have just found out in Nakara, constitutional bench judgment very clearly says, juror relationship continues. The employee, the retired employee has constitutional rights to pursue what happened in his course of employment. So if my lord is going to, whatever is jurisprudence, it will hit both ways. So we'll have to be very careful. Whatever your lordship lays down, it is not going to be only in the government. It will also hit the workman. In given cases, we'll place it.
Enrich it now. Both of you can file your versions.
We reserve the matter.
Yes, my lord. We'll put a good written note. Your lordship has framed a good
Lordship, may keep it for 23rd because I need some time, your lordship. May keep it for 23rd at 2 p.m. Because lordship, I'll do a little bit of research, and learned friend also was saying he will. Therefore, kindly keep it on 23rd. On that day, your lordship, I'll make further submission.
20.
I leave it to your lordship. I can't.
Because today I don't have the file also, your lordship.
No,
I'm handicapped. By my mistake, I approved.
We have understood. If possible, that day we invite you. Please come and argue. That will increase the jurisprudential quality of our judgment. So we request to come.
And my lord, as promised by my friend on all earlier occasions, he will ensure that 24th matter is posted in the CAT. He will not insist on the contempt. That's all.
No, that's why I'm saying 23rd. That's why I said 23rd.
No, for any reason it gets adjourned, you have to ensure because your request is adjournment.
Don't worry.
We will say right now. The matter was extensively argued by both the sides. First up, learned counsel appearing for the petitioner wants to do some research and revert. We agree. First up, learned DSG submits that there is a hanging sword of contempt proceeding pending before the CAT, and therefore the same needs to be kept in suspended animation. First up, we agree with this also. Okay, call this matter on 24th, all right, 20 instead of 20. 24th.
24th will be Friday, your lordship, with single bench. 23rd is that.
23rd. Thank you so much.
Extremely very enlightening. Pleasure to address this bench. Very learning. Thank you so much.
You have a lot to learn, Sage, also, your lordship.
Pleasure. Thank you to my good friend Tushar. Thank you, sir.
Thank you, sir. Thank you.
Yes.
Well, I'll leave it from your lordship. Good.
Thank you, sir.
Lordship, I'm thank you, sir.
Supplementary list item 17, date April 1367 of 2025.
Thank you.
Yes.
I am for the appellate.
Yes, sir.
Which was referred to full bench for a determination whether under the GP Act 24 2C.
Just give the foundational fact. Don't.
I am the elected Sarpanch.
You are elected Sarpanch. When the election took place?
2020.
You don't have date settled in your report?
Yes, please.
Election took place from 1st of January 22 to 31st December 20.
Sorry, ma'am.
Okay.
2-3-2020.
2-3-2023.
2nd March 22.
22.
Yes, ma'am.
Election happened on 2-3-22.
The result was heard on 2-3-22. I was declared elected.
Polling is 11th January.
11th January 2020.
Polling is different, election is different. Yes.
So 2-3-22, I was notified as the elected Sarpanch, the Gram Panchayat.
2-3-22.
Yes, madam.
Whether in your state Sarpanch is elected from the constituency or elected members will choose him?
No, it's directly elected.
From the
elected.
Oh. Yes.
No confidence motion. Notice of no confidence motion was issued to me.
On
29th November 2024.
29/11/24. Yes.
I challenged the notice in a writ petition before the Lord Single Judge, contending that the notice did not come.
That full bench you had argued.
Yes, ma'am.
Both you are here.
Yes, this is that case which was referred to full bench. This writ appeal was referred to the full bench for a decision whether both the documents are mandatory. The requisition.
We held it, they should accompany.
Yes. Now, my lord, this writ appeal has come to decision in terms of the full bench judgment. And in full bench, your lordship said that those two documents must accompany the notice. And
you are referring my judgment.
Yes.
Some Navanita Krishna something.
Navanita Kapat. This is the case. This is the writ. Navanita Kapat Patra.
It is Krishna, Lord Krishna. Navanita means fresh butter. Kapata means fraudulent, tactical. And Kapata Patra. One who plays that role is Krishna only. Yes.
And in the full bench, your lordship held that the notice is that since it did not contain the proposed resolution, it contained only the requisition. So in terms of that, my writ appeal is to be decided by this division bench now. The Honorable Single Judge rejected my appeal, dismissed the writ petition, holding that both need not be
following another DB.
Yes. Then matter came before a division bench. Division bench entertained a doubt with respect to 2014 decision and referred it to your lordship, and your lordship categorically held those two documents.
So question of law is answered.
Yes.
That notice of no confidence motion should be accompanied by the requisition moved by the members and the proposal to be sent by the subdivisional magistrate. Who is that?
Yes.
Subdivisional magistrate?
Yes, subdivisional. Yes.
Your lordship hold the requisition must accompany along with the proposed resolution. There was a special resolution. Your lordship hold that special resolution will not do. It must be a proposed resolution. In fact, the proposed resolution lordship was not there. Therefore, your lordship directed hold in the bench judgment that proposed resolution must be accompanied along with the requisition. And in fact, in this present case, the notice has been issued with the requisition and a special resolution, Swatantra Baitak, to which my friend objected. It is not satisfying the requirement.
No, you said some word in
proposed resolution.
Proposed means?
The statute requires it is a proposed resolution. The word used in the resolution is the Swatantra Baitaka, special resolution.
Swatantra is not special. Vishesha is Swatantra is independent, separate.
Therefore, that is not the proposed resolution. Therefore, your lordship answered, these do not satisfy the requirement of section 2. Therefore, your lordship answered that. Then only question arises here. Your lordship found the notice issued by the sub-collector is not in accordance with law.
Where is that finding?
Yes.
We answered on facts also.
Yes.
Because we did not decide that since it was a reference on law.
The reference, it has to be done.
Nothing, what remains? So better dismiss.
Yes. Writ appeal is to be allowed. Writ appeal is to be allowed because my petition was dismissed. I came in a writ appeal.
Whether we have recorded a finding.
Yes.
On fact also.
Yes.
Apart from answering the question of law. It appears, I vaguely remember. There are not that judgment. There is that judgment.
It is
there.
So Samal, you are discussing it from resolution to proposed resolution.
No,
Proposed resolution.
Yes,
Yes, yes.
that will be here speaking.
Yes, yes.
It is called in English.
Sorry, stand corrected.
Yes.
Yes. In the meantime, what happens? Pursuant to that notice, there is a government notification in declaring someone as elected. Whether that notification issued by the government
Will go.
it will go. And what is the next? Therefore, I am taking your lordship to the provision under section 24(3) of the Odisha Gram Panchayat Act. Yes.
It appears we have discussed 24(3) also.
No,
Not discussed.
no, not discussed.
Go to the judgment. Some of
3 is not discussed nowhere. Because that question had not arisen. The 24(3) provides that in the event it is found there is no resolution taken place, then it is at the liberty, the bar of 1 year will not made applicable to them. So suppose there is a valid resolution and the resolution failed, for 1 year there will be bar.
again you cannot move. That is moratorium period.
Moratorium period. That is not applicable to the present because your lordship found there is a mistake in the notification itself, the question itself. Therefore, your lordship is quashing the notification.
Correct.
Therefore, your lordship may kindly have a glance for a minute to the provision I am reading.
24(D).
24(3).
3.
Madam. When
The meeting has been held in person.
When a meeting has been held in person of section 2, recording one confidence in the sarpanch, naib sarpanch, as the case may be, no fresh requisition for a meeting shall be maintainable. A. In case of falling under clause J, I and J, and the said subsection for where the resolution of the defeated after being considered at the meeting so held before the expiry of 1 year from the date of such meeting. Meaning thereby, if there is some deficiency in I and J, for which your lordship is holding that there is defect in the notice and your lordship is quashing, therefore the opposite parties are at liberty to make a fresh requisition and a resolution in accordance with law. That part has been taken consideration in another judgment of this Hon'Ble Court in the class 232. Detect. Vijay Shukla. There is some meeting. Detect.
Proceeding by which he was removed is bad. Sir, now the full bench we have recorded a finding of fact also.
Right.
Fact is a finding against you.
My lord.
Therefore, he has to succeed.
My lord. Absolutely.
If succeed means what is the question now?
Yes.
Succeed means because everything is set at naught, he will be reinstated.
Right.
Unless there is another law.
Right. So that is absolutely right. Here, your lordship is interfering with the order because there were certain latches in the notice itself.
Correct.
Therefore, if there is some latches in the notice, then it is precluded the ward members to make a recruitment afresh.
Fresh, yes, who is saying they are precluded?
Yes, therefore I am meeting the judgment of a coordinate bench of this Hon'Ble Court.
No, are we precluding you?
Therefore, I need an order from this Hon'Ble Court in a similar circumstances in a writ of will, coordinate bench, while interfering with the notice and quashing the notice, hold that however, we made it clear that there is part of the requisitionist to make a fresh requisition as the embargo of 1 year is not attracted in the instant case, and in the event such requisition is made strictly in adherence to the provision of the statute, there will be no fetter on the part of the competent authority to act as permissible in law.
Why we should write that? We will not write it. Law is declared with a diligence. Then no law will be followed by that.
This is because your lordship, because it is necessary. Otherwise, another round of litigation.
Yeah, you will have another case also with you. What? How can we block all litigations that way? We will not give that. If now law is declared, now if you initiate, you initiate. If it is wrong, he will challenge it. If it is right, he will say. Why we should give advisory opinion? Apex court can give advisory, not we.
Because the statutory requirement is there.
Yes, it is there. Statute is there. The interpretation is there.
24(3) is there.
That question will not arise. That question arises only when you do it. In advance, we cannot give anticipatory relief to you. That's not the object of it. We understand.
That is the law decided.
Now we have to do the That's what. That is law. How can we give it jurisdiction? This writ appeal is allowed in view of the division bench decision. Full bench decision made in the very same appeal. One judgment dated 29/11/2025. First of all, second, the order of the learned single judge is set aside. Seventh, the writ petition number so and so filed by the petition, the appellant 31072 of 2024 is allowed. Seventh, a writ of certiorari is quashing the what order to be quashed?
Notice under Annex 1.
Notice dated
29/11/24.
29/11/2024 at Annexure 1 to the WP. Annexure 1. At Annexure 1 to the WP. And as a consequence, all further proceedings structured on that basis stand voided. First off, as a further consequence, the appellant shall be reinstated in the office of the Sarpanch.
Hatimunda Gram
Panchayat with the immediate effect. With immediate effect. First off, first made it easy. Open. Yes. Please. Yes.
List item 6, writ appeal 514 of 2025.
Two appeals were there in item number 17 also. The point is same, the case is different.
In your separate case it is. Yes. Mr. Samal said.
Mr. Advocate G.N. Mishra was the leading case. Thereafter, there are two cases.
Your case is also there. That relates to whom?
Relates to 24 GPA.
Another servant.
Point is same, case is different.
Argue, let us see. Who is your opponent, friend?
In the state, and Mr. Poti was the intervener during the appellate stage. Mr. S.R. Satyaranjan Pati.
You appear for him. You are ready in the matter. We are asking you. We are not asking you to talk into story. Are you ready in the matter? You tell that. When will you be ready?
Next week.
Well, next week, question.
Another also with
this also?
yes, ma'am.
Totally three matters.
Three matters.
Who is your opponent?
Here, my lord, Mr. Subsen.
Same. Then we call that also same thing.
Sorry, my lord. This here state is only.
State is the party. Only state is the party.
Yes,
All right.
my lord.
Malati Bhoi.
Malati Bhoi.
992.
Yes, sir. 992.
Yeah.
My lord, just to recapitulate, my lord, there was some delay. The Honorable Court has condoned the delay.
Okay.
Now, my lord,
Tell us the foundational facts.
my lord, here I was elected as Sarpanch.
Election took place when?
My lord, election took place 11/1/2022. And I assumed the office on or the result declared 2/3/2022.
Brother,
Yes, your lord.
those who conduct election cases,
Man,
there are three important cases which they should study.
man.
First one is 1951 Supreme Court. I forgot its name. Like Om Ganesha Maha matter.
Like 55 matter.
That way. 51 Pannuswamy, NP Pannuswamy versus
Yes.
returning officer Namakkal. That is first judge. Then Mohinder Singh Lee, second one.
And
AC Jose
this is those and
is three.
lastly, your lordship, that was just
Why you should say election jurisprudence has been developed in this country as an independent branch of law. See, when we said election, you said polling date. This problem arises. Election is defined by the apex clause. Election is a process beginning with the issuance of the notification of election, ending with the declaration of result of polling. That's how courts have said. Therefore, just have this in your mind. That we you for us also.
2nd March 2022, declaration of result.
Election to polling took place when?
11th January 2022. Yes, sir.
And results were announced on
While continuing as
ready.
Apology, madam.
Yeah.
Not call this on the same day so that.
At the request of learned AG. Yes.
In the other matter, I have put a short note.
In this also, it took the lead.
I took the lead.
At least you have a short note. That becomes easy for us.
I have given the detailed date chart, but notes, I think I can apprise your lordship better.
All right. Yes.
Within this, item 6, writ appeal -4 of 2025.
May I please? Well, this is an appeal filed by the ocean. The issue involved is the correctness of the answer in respect of one question.
Correctness of answer in respect of
One question, whether the answer is A or answer is B.
Any key answers are given?
Yes, but key answer is given. The learned single judge has accepted the answer proposed by the respondent and set aside the answer key set by the expert committee.
What was the question?
The question, if your lordships may kindly have, the judgment starts at page number 10.
Paper 2 set A.
Yes,
number 100, paper 1 set A.
But it is recorded as paper 2 set A, question number 33 at page 12 of the judgment.
Page 30.
Page 12 of the judgment. internal page 12 of
the first edition of Organon was published when Dr.
was
that
Torgau or Leipzig. Those are the two. That is the controversy. Whether the answer is Torgau or the answer is Leipzig.
What is that organ?
It's supposed to be the Vedas for the homeopathy.
That founding father of homeopathy.
Homeopathy, yes.
Okay. It was published.
Yes, ma'am.
When he was
at Torgau.
When was published when Dr. Hahnemann was at. Well, I'll just give your lordships a view of what happened. Nowadays, after the examination is held, in this case, the examination was held on 3rd of December 2023. 4 days later, on 7th December,
23. 23.
Yes, ma'am.
Exams
were
written exam.
Yes. MCQ type written exams. Multiple choice question.
On 7/12, what happened?
7th December, we published the provisional answer key and we invited objections from candidates.
Answer key means the answer.
Key answer. Provisional answer key. And we invited objections from candidates, whether any question is wrong, whether any answer is wrong.
Yes.
We received
objection for filing objection suggestion. What was the last date? How many days?
7. Within 7 days.
You have said that.
Yes, ma'am. Within 7 days. That notice is also there. That notice is at page 65, annexure 6.
Then what happened?
In respect of,
objected.
In respect of this question, in the provisional answer key, OPC had marked the answer as A, Torgau. We received objections that the answer should be B, like it. All objections are always referred to the expert committee, and the expert committee also said B. So the answer was fixed as, in the final select list, the answer was fixed as B, Leipzig. Because the petitioner, the respondent challenged this change in the answer. And
your key answer was A.
First it was A. After candidates issued objections.
Who filed objections? Those persons filed objections.
Multiple people. Annexure 7, page 73 is our list of objections. We have annexed.
In respect of question number 33.
Yes, ma'am.
Your provisional key answer it was.
Provisional was A.
A. Then objections were filled, and thereafter you said it is
B.
You said B.
B.
When you said B, which date?
14/5/2024.
14/5/2024.
14.
This was on the basis of expert committee report.
Yes, ma'am. Expert committee.
Committee report dated?
But there is no date.
There is no report, ma'am.
There is no report. We published the final select list on 14th May.
There is no committee.
There is
at all.
absolutely no committee report.
There was a committee report called for by the learned single judge. That report is on record, ma'am.
The first question has been answered. Second question has not been answered there. And the committee report is not based on a single book, my lord. That's the plain opinion of the experts, so-called experts, because they changed the other day. After they have set the question, holding A to be the correct answer, they have changed their opinion to B on the basis of the suggestions of the examining candidates.
How the expert committee on what it worked?
Well, once objections are received from candidates, well, if your lordships remembers, recently your lordships have given a judgment where the answer key was published after the results were announced, and your lordships had taken a dim view of that should not be done. So in 2023, the process was changed. It was revised. And now after the question paper is issued, we invite objections from all candidates. And when these objections were received, the objections are at Annex 7. These objections are placed before the experts who had prepared the question paper.
How experts have arrived at that conclusion? On what basis? There are standard books, I think 3-4 books on the founder of homeopathy.
I have read 14 books. 7.
In which book it is said like that?
That is there in the expert committee report, which was called for by the learned single judge.
Therefore, now we have to look into that, no?
Yes, but that was kept in yield cover.
The famous statement. This famous statement. Heidelberg. When I went, I saw that very famously. He said, "Similia similibus curenta." For similar things, similar disease, which are caused by bacteria, similar bacteria should be the answer. Something like similar. This is how it is written. I remember vividly when I went there. Similia similibus curenta. Standard books about it. It is not something very doubtful. It's not like that. So how the committee, who are those experts? What is their expertise?
Well, they are all professors and assistant professors from various disciplines, from the homeopathy discipline, from various universities across the state, across the 3 months. They are picked at random, and their names are kept anonymous.
See, Section 45 of C, Evidence Act. When an expert gives an opinion, the basis on which expert has tendered that opinion is one. Section 45 reads that it is interpreted that way by a. Therefore, on what basis the experts have said that this book was written, which was in this place or that place? Where is that?
That basis was called for by the learned single judge. It has been kept in sealed cover in court record.
We'll open it.
But what the learned single judge has opined in the judgment is, in an earlier examination for the same posts, this same question was provided for, and the answer was A. And that is the reasoning of the learned single judge, that the answer cannot change. What the learned single judge lost sight of.
How can we change the answer subsequently because of our judgment, which you had argued?
Here that is not the case. Here the learned single judge compares 2 questions and says that because 2 questions are the answer cannot be different. What the learned single judge failed to appreciate is there is a subtle difference between the 2 questions.
Which are those 2 questions?
Yes, ma'am. If your lordships may kindly compare page number 12 with page number 14. There is a very subtle difference between the 2016 question and the 2024.
What was that question? Let us see.
Page 14.
One second. We'll hear you. We'll fully give a full opportunity of hearing to you.
Page 14, my lords, question number 31. The first edition of Organon of Medicine was published from.
And the other question is?
The other question is the first edition of Organon was published when Dr. Hahnemann was at. a very subtle distinction, and in fact, even I had failed to point this out before the learned single judge.
No, it's very apparent. The first edition of Book of Medicine was published from, and the second one is when he was asked.
Where he was done.
Oneness of publication of the book. Other one speaks of the authors when publication took place.
Yes, ma'am.
My lord.
And the reasoning of the learned single judge is at page 24, paragraph 25 on.
And this is the event of 1810, my lord. When actually you cannot move out from your house to get it published from somewhere else, my lord.
We do not know.
Neither there was any vehicle or anything. But anyway.
How to pronounce it?
Torgau. Torgau and Leipzig.
Substantiated the qualitative reference further that this also has been the same question, correct answer. So that is apparent on the face of the
yes,
now, even otherwise, two reasons are coming from paragraph 23. One is
books.
One is books.
Yes, ma'am. That has been elaborated in paragraph 28.
28. Other is in the earlier examination, which may not be correct.
Yes.
Even if that part is amputated, the first part will remain intact.
Yes, ma'am.
Then where is this for you?
No, because the first, with respect to the books, the experts have in the report which is kept in sealed cover.
Let us see.
Have opined that the answer.
No, why sealed? Cobra.
No, it can be opened.
What is that? Open it. It's not an official secret.
You have opened the answer.
Well, it is the academia only to keep the names of the academicians sealed.
What is there? Where is that?
That is there in the writ petition records.
So we have it.
Records in
from the storehouse. What is called the storehouse?
May I say one thing? Let him submit a single book wherein it is.
Let us see also the bunch because it is kept in sealed cover.
Yes. And
suppose in sealed cover, if there is a book.
That I think cover that I have also seen in the book, but I have not gone through.
The relevant pages of the book are kept.
And one more factor, Millet. 331 candidates marked Torgau, 435 candidates marked Leipzig.
There is not a democratic process.
103.
There is not
it is not a democratic process, but it is when
we come back to you.
When there is a controversy which has arisen and a majority of the candidates have found the correct answer.
Suppose at one time, majority of the people on earth believed earth is not round. Only one person said,
Your Lordship,
Galileo, he said earth is round. So far as truths are concerned, can it be decided by majority, minority, etc.? It should be decided on its intrinsic value.
Well, it only indicates that this is a case where there are books supporting both answers.
No.
In fact, if your Lordship see the objections at Annexure 7, page 73.
Annexure 7?
Page 73.
What is that?
That is the objections that received from candidates.
What are you going to do with the objection? Now, very simple. When that publication took place, where the author was,
yes,
that is the only
short point.
And you purchase the material, we can find out from textbook.
Well, can I show the textbook? I am having it here.
Who is the author? What are the credentials of the author?
Well, I am submitting one after another.
No, credentials of the author.
My lord.
How to believe that author?
This is Dr. Mahendra Singh, Dr. Subhash Singh.
Where did they study?
And publishers. And this is from the ISBN publications.
We do not know that all that. What is the credential of these authors? Were they in Germany? Where they
were
study? Where?
All the books were in German. Subsequently, they have been translated. Dr. Mahendra Singh and they translated by Dr. Mahendra Singh and Dr. Subhash Singh.
Translation
of
original work.
translation of the original. I am showing the original work also.
Slowly, you have to go slowly. You are lacking the jurisprudential quality.
This is the original.
Please understand, the view of the court says where expert view is given, the credentials of the expert should be established at the first time of his seat. Then he becomes the expert. Then his opinion assumes expert opinion, not otherwise. Therefore, first you should say who are whether any court considered their version. Because any author may say anything.
This is written by Dr. Samuel Hon'Ble himself.
Saying, he said when this book was published, I was in London. What has he said?
Organ of Medicine, first edition, the frame.
Correct.
The first edition was published in 1810. When was at 12, he was 55 years old.
Who said that?
Hon'Ble himself.
How he will say it in pronoun? I, instead of, he would have said I was there like this. How pronoun comes there? He is writing. Why he is writing pronoun?
Third person. It has been translated into English, my lord. It is his own first edition.
Even if it is the third person, it appears to be in third person.
Why that?
He would say I translation, even if translated.
All are translated.
No, translator will say
it cannot be translated at all.
There is no other book, my lord, without translation. No other books in English.
Then expert opinion.
Expert cannot write some. This is data, my lord. Expert cannot write anything.
Correct. But suppose some expert has to decide
this is not including inferential process, my lord. This is not including any inferential process. Suppose it is simple fever, whether it is malaria or cholera or anything else. This is an inferential process. But when it is dependent on the data only.
No, if it is translation, why it is in third person?
Now, in Wikipedia also that and Google Wikipedia also that answer is there.
Wikipedia is a third-party software which anybody can edit with. That is
not authentic.
Not authentic.
The Apex Court said about Wikipedia.
It's Wikipedia. I can open up Wikipedia and edit it right now.
So that will show that one only.
Yes, ma'am.
So all the books, they are all textbooks.
Which are the other books?
This is book number 1. I'm giving it.
Who has written? What are the credentials of the author?
These are credentials of the author. He was Mahendra Singh.
It is again a translation of the book of Dr. Hon'Ble.
All are translated books of Hon'Ble. I am having 14 of them. All are translated.
No, that's all right. Whether all they say where he was when the book was published. Where is it? What kind of question it is? When Hanuman had shaved last week, what kind of question? Nothing.
We are dependent on the experts. These
question
setting because the Public Service Commission does not have because we conduct examinations for homeopathy, for dental surgeons, for medical surgeons, for civil servants.
No, the question, sir.
We rely on
when that was published, where he was, whether he ate upma or idli in the morning. Those questions, what kind of questions? Where is the profundity, elements of profundity in the questions?
Bookmark pages,
which sentence, brother, which says that he was in X place when book was published? Where is that? Read.
Bookmark is there, madam.
Bookmark is there, but 4 columns are there.
Part column itself says it, madam.
Read.
The first edition was published in 1810. Anyone page 96 of the WPC. Relates to my WPC.
Not supported, man.
No, I have got that. Open up that seal cover. Seal cover? Mystery cover, huh?
No, it must be with the registered judicial.
Registered judicial. Yeah, bring that.
In reference to this writ petition, you must be.
Book 2 must be seen, madam. I have given. Book 1.
Another.
I have already handed over.
You support the reasoning of the learned single judge.
My lord. Because the single judge has passed the judgment relying on the books.
Why he discredited the expert opinion? Where is the reasoning?
The expert opinion doesn't rely on anything.
Where is this? No, that's what you are saying. Where the learned single judge has said.
Because I have not seen the expert opinion and single judge has not discussed it. Because to my information, my lord, the question number 1 was there only in the expert opinion. Second question
Where
was
is
not.
the reasoning of the learned single judge as to why he jettisons expert opinion?
Because there is no, there is nothing mentioned in the judgment itself.
Nothing mentioned.
From
That is, I wanted my lord to place the judgment first so that he may point out which age objectivity.
No, he is saying expert opinion is there and we have gone by expert. We don't have expertise. We depend upon expert opinion. The experts have given this opinion.
But
we act upon that. But learned single judge, he says, I will not accept that expert opinion. Why? No, where is the reasoning?
That is, if he has relied on the books and expert opinion has not been.
No, he has to give reason why we are not accepting expert opinion. Apex court said, in which is that judgment? Yeah. BC Mailarappa. BC Mailarappa alias Melurappa versus so and so Venkataramanappa. Take up that judgment, 2008 SEC. Supreme Court says, when experts give the opinion, the court loathe to interfere. This is the sentence.
That is here.
Court should not interfere.
All the decisions should be, my lord.
They have said like that. But very reasoning, one line reasoning of the learned single judge, why he discards expert opinion. Where is the reasoning? Know that. Not even one sentence. It is always open to, but sparingly.
Your lordship from Pada 25 onwards, my lord.
Yeah, only that much you have to show now.
Pada, page 24, Pada 25.
We are asking you, where is the reasoning of the learned single judge saying this expert opinion is not acceptable to me because it is not founded on any evidentiary material. Therefore, I do not agree with this. Therefore, I travel to other books based upon which I
therefore, I am taking your lordship to the Pada.
To show that, only you showing that.
With respect to question number 33 of paper 2, set A, the petition contents. The 8 Tralgaon is substantiated by authoritative and widely recognized reference textbooks. It is further asserted that this answer was deemed correct in the UPSC examination conducted in 2006.
That is wrong. That we don't agree. When you said it is wrong. We appreciate that.
However, in the year 2024, the same question's correct answer has been.
That itself is wrong. Go to the next point.
Now, this court has taken note of the fact that the question is unequivocally objective and straightforward. There cannot be an opinion because the question is factual. A brief review of question paper 2, set A for the year for the 2016-17 recruitment of homeopathic medical officer, that the same question of 31 quoted shows that the key model answer for OPSC, the correct answer is 8 Tralgaon. The same is present below.
No, it is the same analysis.
Same analysis. Therefore, we leave it. Then coming to part 28. Moreover, the petitioner has substantiated that the correct answer to question number 33 of paper 2 set A 12 based on authoritative references, notably organon of medicine by Dr. Mohendra Singh and Dr. Subhash Singh, comparative study of organon by Dr. G. Nagendra Babu, and the life and letters of Dr. Samuel Lennon by Thomas Lindsay that collectively confirm that the first edition of organon was published in Telangana in April 10.
No, we are asking not of that. We are not here on that. This is a writ court. Because we are reviewing the order of the writ judge. Therefore, what writ judge can do, we can do. What we cannot do, this judge could not have done. We are asking you, what if the writ judge discarded expert opinion? Simple question. Because apex court said expert opinion should not be discarded by the courts. These are academic matters.
But the apex court also said that the expert opinion should be based on authoritative books.
But that is not the reasoning. We agree with you. That is not. That is what the learned sentence is not. Let us find sentence about that.
Let us find out from the.
No, there is no reasoning. Three lacuna. Number one, the discarding of the expert opinion without saying one single word about experts. Number two, learned single judge grossly erred in saying there cannot be opinion facts. Read Article 143 of the Constitution. There can be opinion on facts. Whether Ram was born in Ayodhya, opinion was sought for from the apex court. Ram was born is a fact. On that we form an opinion. Therefore, learned single judge may not be correct in saying there cannot be opinion on facts. There can be. Number three, learned single judge equates 2024 question paper with the 2016 question paper.
On the books. I'm not going relying on that earlier question. If you would like to diffuse that, I'm not relying on it. I'm relying on the books.
That cannot.
So,
but
if they have
at least expert, so sustain expert opinion, at least that the report we have to see. In this only time is
Your Lordship, call this matter on next week any date. There is also another, there are two writ petitions which are tagged along. It's a common judgment. The other writ appeal may also be listed along with.
It's also there.
Yes, but the writ appeal is not listed. Yes, ma'am.
All this. See how much time we have spent on this. This matter we got to next, along with the appeal number.
But I'll give it in I'll slip of it.
For further reading. On that day, in field cover, we placed made to be placed we made available by the registry.
Called by the learned single judge V-Day, order dated 4th November 24.
Bring some judgments, how
yes, ma'am.
Expert opinion to see that judgment. We will read, just give the citation.
Yes, I'm handing over
that notes and give us.
Yeah, they are on Rahul Singh.
The focus class is Kanpur University.
That Amit Gupta gives. That also about.
Kanpur University is referred to in this judgment.
No, the judgment which says what is meant by expert opinion.
Very well, ma'am.
This only expert opinion should not be interfered.
Yes, ma'am.
Correct. But what is that expert opinion? When to call an opinion to be an expert opinion?
Very well, ma'am.
Very good comment there by Woodruff and Amirali under section 45 earlier evidence act.
Madam Patel, madam. It has been decided.
What is decided?
Madam Patel, this what the expert opinion and how it should be dealt with.
It's stated. Give that citation. They make notes and give to me. Yeah.
High Court of Jurisdiction at Jaipur. SP bill the petition number 18-130-2023.
Yeah.
List item 14, the appeal 444 of 2024. List item 14.
Item 15 is mine. I am at 15.
Item 7 double A of 2024.
This is only in respect of the
Matters have passed over. At the time of call, no one is there.
Your function is not here, so I put it up here.
Item 14.
Is a Rafiq Mercy.
13, 14 and 15.
15.
One payment. You are respondent.
For the government, state.
You are for the opponent.
I am for the opponent. Madam, the default has been for the period of.
What was the designation of the employee? Rafiq Mercy is acted upon.
Madam, recovery has been stayed.
What was
recovery has been stayed and money has been given to the
person doing?
Madam, he was a fishery job.
Is that the extension officer?
Fishery extension officer.
Fisheries extension officer.
Madam.
But Rafiq Mercy considers only group C, D.
C and group D.
C and D alone.
C and D.
But he is officer.
He is an officer means C class.
Huh?
C, group C. Group C.
Group C.
Madam.
Where is taking?
I have not stated any of group C.
Then you are saying how to?
Madam, that even group C officer he worked in a block, my lord. Block office, block development office. Block development.
EDO. EDO.
FEO, fishery extension officer.
No, the petitioner has been upgraded to group B employee. But Rafiq Mercy judgment is not applicable only to CD. Your claim is this. It is also applicable to him. You are claiming it.
I am applicable.
But he is a group.
Yeah, that is applicable to me. That part is gone, my lord. I have already got my payments also. But my landlord has restricted the interest to be at 7%. That has also not been given.
18%.
I pay for 18% on the basis of their own circular, my lord.
18%.
18%. State government has issued a circular that whenever there is a delay of
pensionary benefits.
On pensionary benefit.
Not this.
It's a pension.
It is a pensionary benefit. Gratuity and pension.
Where is that circular? Is it true?
Madam.
But yesterday also, Malors has fixed that amount, which was 18%, that was reduced to 7%.
No, we only did not interfere. That was a reverse case, where it was 18%, then removed application, and that was scaled down to 7% in the single judge. Even that way, it was charged by you people. That we dismissed, that's all.
Here, the
reverse of.
This is page 59, the circular here, page 59. But the circular is emanated to the division bench judgment of the Hon'Ble High Court in the case of Dhruvacharan Punda. Circular is prepared only as per the direction of Dhruvacharan Punda.
Will not be.
Page 59, Annex 5. Timely payment of pensions by the pension sanctioning authority and payment of interest on the delayed payment of pension by the person concerned. Relevant para is page 61, para 2.
61.
Page 61. For sake of daily reference, the extract of the para 18 of the aforesaid judgment dated 8/9/99 of the Hon'Ble High Court of Orissa is introduced to below. We dispose of this application with the direction of the state government to administratively instruct all the heads of department and the concerned officials to ensure that different steps prescribed to be taken under rules are rigidly followed and any non-observance thereof is to be strictly viewed. If there is any delay in payment of pension, the pensioner shall be entitled to 18% interest per annum for the period of delay, and this interest shall be recovered from the person or persons from the delay. While the rate of interest, we have kept in view the minimum bank rate of interest charged for borrowing from bank. This aspect shall also be notified to all concerned. We are sure if such stringent steps in addition to those which the state government may feel necessary to impose are taken, there shall be strict compliance of the requirement of rent in future. The old retired person shall not be required to move in the corridors of the court with tears in their eyes and a faint ray of hope of getting remedy early and not posthumous.
In pursuance of the orders of the Hon'Ble High Court, it is hereby instructed that all concerned should immediately follow the time-bound schedule for the mentioned above. Otherwise, the pensioner will be liable to get interest at the rate of 18% per annum for the period of delay, and this shall be recovered from the persons or persons responsible for such delay. In case there exists sufficient reasons for non-sanction of pension and gratuity by the date of retirement, the pension sanctioning authority should see that the retiring government servant is sanctioned with provisional pension and provisional gratuity as provided under Rule 65 of OCS Pension Rules 1992. For the purpose of grant of provisional pension and provisional gratuity, in accordance with the aforesaid rule, pension and pension sanctioning authority need not either insist on or wait for a formal application from the retiring government servant. At times, pensions are not finally on plea that the information
No, well, the amount that was recovered.
21.
Amount that was recovered.
Excess.
How much amount was recovered?
21,764. That is excess.
1,700. How long it was retained?
And for that,
How long this amount was retained?
for the period from
7 years.
7 years, 9.
Yeah, what do you say? Any French circulars have been issued prescribing different rates of interest? After this judgment was rendered when?
This was of 99, bro.
899.
14 वर्ष इंटरेस्ट रहा है 14 वर्ष दिले इंसान पैसा 17/2009 to 11/2023 they didn't give 17/2009 to 21/11/2023.
Yes, what is it, Mr.
Circular of 99.
Correct, unless that is repeat, that will continue.
We may search for any other notification subsequent to that.
There is no notification for that.
Because 26 years in the meantime.
You could have, had there been one, you would have put it across the bench the other day when you argued the matter with before the learned single judge. You repealed, new circular has come, bank rates have depleted. These things you would have stated. Where is that one? Which the Vigilance bench has said it appears to be true also. Many pensioners we are seeing, they are just hovering in the court corridors with the tears in the eyes, as the judgment says.
That was the language.
It's truth also.
I waited for 14 years. Now also I have not got it.
How much interest you will get? That money is not yet paid to you.
No, interest is not a single by interest.
You have been released with the provisional pension or not?
No, I was given the provisional pension.
Entire retirement benefit amounting to 7 lakh.
This amount minus this amount.
Minus this amount, 21,000 somewhat.
You pay another 21,000 rupees.
21,000.
How much it will be?
Well, it will be almost few lakhs.
How?
13-14 lakhs.
How? 13 lakhs. How?
7,53,398 is the amount.
7 lakhs?
They have kept it for 14 years.
No pension was paid to you.
Provisional pension was being paid to me.
How much it was paid?
Some 30,000 something.
Whatever. What is the quantum? It's 50% of the.
No, my lord. Provisional pension was given on the basic rate 2% of the 50% something.
Pension, what is the rate of pension?
Maximum 30,000. My word. I do not know what he was. But the court has given the direction to pay him 7 lakhs 53. May I take it also to 6.2? That he had paid 50% of the premium.
At the rate of 7%.
At the rate of 7%.
The court is also viewed that since for recovery 21,000 somewhat, the entire retirement benefit of the petitioner amount to 7.3.398 was withheld for the period. Petitioner is eligible and entitled to get interest of 7% per annum on the said amount
2009,
starting from
21/11/2023.
See, further, you wanted to retain, your case was 21,764 was paid in excess. That amount you could have deducted and released all other. You did not do that.
That is what the court has said.
Therefore, court said you pay interest. Now he is aggrieved by the rate of interest.
Only the rate of interest.
That's the only case. Why he should suffer for all these years? If at all, if we are 21,000, you could have deducted 21,000 and the rest.
I have got my 7 lakh.
No, we are allowing let the government feel the heat. Otherwise, every pensioner will suffer like this.
May I take a chance for the 99 part is concerned, 99 resolution is concerned, which is extended to the 18%. Can I take chance to verify?
We will do it 12%. We will not give time again. We'll give it, we want again matter to be urgent.
No.
12% we'll do that.
Your lordship, I am not arguing point, but your lordship knows 14 years I waited, and the other also they have not paid. That is how they appeal. They have not paid that amount even after the judgment.
That amount is also
not paid.
Because you have filed writ appeal.
Because it was in the...
No, he is writ appeal, not the...
No, this is the writ appeal of the petition.
Being certified with
quantum for that. Because it is from January 2024.
This intra-court appeal by the pensioner calls in question the learned single judge's order dated 31/1/2024 entered in the WPC OAS number 71 of 2016 and 12 of 2017, whereby a direction has been made to release terminal benefits, these terminal benefits with interest at the rate of 7%. 7%. Petitioner the appellant grieves before the court that the rate of interest ordered by the learned single judge is militantly adequate, and therefore the same needs to be enhanced to 18% per annum, keeping in view a coordinate bench decision of this court. You see that you read that judgment now?
Page 59.
Page 59.
Of the state of Orissa, 99 2 OLR.
How slowly I have
99
page 15 is
volume 2,
page 59.
Orissa Law Review 433. The judgment is that and the number.
Case number 6886 of Durba Panda versus State of Orissa, disposed of by a coordinate bench of this court, by order dated
8/9/99.
8/9/99. First one. Next. One more sentence.
Pursuant to that notification.
Learned counsel for the petitioner appellant vehemently argues that pension is no longer a bounty in view of decision of the apex court in DS Nakara versus Union of India, and therefore when it is not paid to the pensioner in time, the same needs to be levied with reasonable interest. First off, he tells us that the petitioner's, the appellant's money was held, was withheld by the state during the period between 1/2009 and 21/11/2023. 23.
Amounting to 753,390.
Quantified at rupees
7,53,398.
7,53,398. 390. First off. Next paragraph. One sentence. Learned AGM Mr. Mohanty appearing for the state and its officials resists the inspection in justification of the impugned order and the reasoning of the learned single judge. And be seated. Sit down, sit down.
May I also add what your lordship said on to the circular may also be taken care. Because government has acceded to him. Therefore, he cannot argue against it.
Next paragraph. Having heard learned counsel for the parties and having perused the petition appeal papers, we are inclined to grant indulgence in the matter, broadly agreeing with the submission made on behalf of the appellant. First one. Since pension is no longer a bounty, and it is considered to be that it is treated as consideration for the past service put in by an employee. There is a justiciable right in him to seek immediate release of the pension and other terminal benefits on attaining the age of superannuation. And if there is delay in release of the same, the pensioner will have a right to interest on the held amount. First one. This is consistent to Apex Court in Padmanabhan Nair versus State of Kerala. Here 85 so 85 so just to think.
85 1 SCC 420.
AR 1985 185 1 SCC
1 SCC 420.
420. First one. Although learned single judge has levied interest, it is the rate is militantly low. That is 7%.
Lordships,
Yes.
So far the percentage is concerned.
Yes.
That 7% may be low, so far the argument is concerned. Why it has been done by the learned single judge, Miller? Under Rule 49 of the pension rules, Miller, in delayed payment, if it is more than 1 year, then 7% it has been specified in Rule 49.
Correct. But Rule 49 is of which year?
Yeah.
Which year? 1992.
1992.
When this judgment came.
That is gratuity.
That is only in respect of gratuity.
Specifically, gratuity.
That is not gratuity.
It's for pension.
All the terminal benefits,
Yes.
this amount also includes gratuity.
No, Apex Court said that. Gratuity includes is a part of pension.
For that
it's
purpose-
payable on retirement.
On return.
It's a benefit.
Pension
Supreme
and
Court
pension
said
benefits.
interest should be paid if terminal benefits are settled belatedly. Therefore, it is one of the terminal benefits.
And that has been paid by the Supreme Court in V.R. Madhavta. V.R. Madhavta.
Statutory interest is 7%.
V.R. Madhavta.
Not pension.
Not pension.
Not pension.
Only gratuity.
That is under the Gratuity Act. Payment of under rule also.
In Vijay Madhavta versus State of UP, my lord, citation 2001 9 SCC 687. 18% interest has been paid over all the amounts. On implied leave salary, gratuity, pension, everything. 5480.
Citation. Just that it will be useful.
2001, 2001, volume 9.
Learned counsel
2001, volume 9, SCC
right
687.
in pressing into service.
L.
Petition. Fine, so do that. In
Last decision of page 2, my lord.
Vijay
L.
Madhavta, State of UP, 2001 9 SCC 687, wherein interest at the rate of 80% is awarded on all the terminal benefits, including the leave surrender encashment. Leave encashment. All this has not been adverted to by the learned single judge, and thus there is error apparent on the face of the impugned order to that extent. First, next paragraph. In the next one more point. A coordinate bench of this court in page 50.
Coordinate bench. This is
In
1999, 2 OLR.
59.
The Supra is observed as under page 61. See, we dispose of this application in things like that. Okay, up to posthumous. Till that you have, so this you have to make it separate. All right. Next one, in those circumstances, this appeal succeeds. So, the impugned order is modified to the effect that the interest payable by the respondents shall be 18% and not 7% for the withheld amount during the period between 1/7/2009 and 21/11/2023. First one, the remittance in terms of the order shall be made within a period of 8 weeks, failing which the interest rate stand enhanced to 24% retrospective effect. The interest component will be recovered from the hearing officials of the department. Okay.
Enhanced to
24%.
That 7% was there.
Enhanced to 18% because apex court said 18%.
Malad says suggested that it is
that because otherwise why you delay the see they work and they retire to get a pension. Should they go on begging with a bowl, begging bowl? They should go to the government. We have worked and therefore kindly give us some pension. No. See the judgment what it is. You should sanction the provisional pension without application.
Timeline has been fixed.
Yes. No, this is the.
It's a state.
No, at all he was supposed to deposit 21,000. That amount could have been deducted.
21% you could have deducted.
Instead, they keep the entire amount.
Just to harass the employees. Or something else.
I can submit it. Because Malad says suggested for 12.
Apex court says we are getting we are he's bombarding the court in what we can do. We can't do helpless. We have to agree with him. So much preparation here. Yes.
Taken on next week as
29. Whichever they want next week, put it next week.
Malad, item 25 taken up.